I ask all their guests today to please take their seats. The Subcommittee on Energy will now come to order. The chair now recognizes itself for 5 minutes for an opening statement. Welcome, everyone. Today, the subcommittee will begin to review bills to modernize pipeline and hydropower infrastructure. We have 10 bills before us. Some have already been introduced, while others are in discussion form. But we already have an extensive record on these issues that these bills address. We begin this Congress by picking up where we left off last year, with hearings on the challenges we face to expand hydro and pipeline infrastructure. We've heard from job creators, contractors, labor, tribal interests, consumers, and private citizens. Today we'll hear from the Federal Energy Regulatory Commission, otherwise known as FERC, the lead agency for these reviews. As we move forward, we will continue to work with the states and other federal agencies that have a role to ensure that we balance the need to modernize our infrastructure with the important safety, environmental, and consumer protections. We'll also hear from stakeholders, both industry and citizen groups. I look forward to their input. I suspect many of these witnesses will tell us that we have heard for a while now. Getting these projects done has become an incredibly difficult process. These projects need to be reviewed and they need to be safe. But once we've done our due diligence, foot dragging is malpractice. We need to fix this and get it right. Together, these 10 bills represent the beginning of an effort to modernize our energy infrastructure, improve access to affordable and reliable energy, and lower prices for consumers. I want to thank the witnesses for appearing today before us and look forward to their testimony. And now I yield to the ranking member, Mr. Rush from Illinois.
I want to thank you, Mr. Chairman. Mr. Chairman, before I begin, I just want to make a point. I am really concerned about Chairman Upton and our friend Representative Long. I understand that he's over at the White House, and I just wonder, is he okay, or is he? Should we have a moment of prayer for him, or a moment of silence?
He's doing just fine. He's okay.
Well, I want to thank you, Mr. Chairman, for holding today's hearing on expediting the permitting process for natural gas pipelines and hydropower projects. Mr. Chairman, the legislation before us streamlining natural gas pipelines appears to suffer and to offer a solution in search of a problem. FERC data shows that between 2009 to 2015, over 100 major natural gas pipeline projects were approved, spanning over 3,700 miles in 35 states, with a total capacity of over 45 billion cubic feet per day, and an overwhelming 91%, Mr. Chairman, of applications were decided within 12 months. More importantly, Mr. Chairman, without a quorum at FERC, no new project will get approved, so rather than proposing changes to a process that already works, we should be reaching out to the administration and urging them to submit candidates for the commission, as well as for the other departments that are under our jurisdiction that are still waiting to fill important vacancies. Mr. Chairman, there may be some areas where we might be able to find bipartisan support and compromise, such as streamlining the licensing process for hydropower infrastructure. However, Mr. Chairman, and as the April 27th letter submitted to UN Chairman Walton from myself, Ranking Member Pallone, and other colleagues indicated, it is critical for the subcommittee to hear from other important stakeholders who will be directly impacted by these changes, including the states, resource agencies, and Native American tribes. Mr. Chairman, I also have concerns with the cross-border bill, which would shift the burden of proof to opponents of a project to show that the project is not in the public interest. This bill also limits the scope of review for large transnational pipelines to only the tiny section of a project that physically crosses the border, no matter how many communities, states, and properties the pipeline might actually traverse. Mr. Chairman, as the recent Oroville Dam failure demonstrated, expediency must not trump safety, and public comment and engagement must continue to play a vital part of any permitting process. So, Mr. Chairman, before moving forward on these bills, many of which would make it easier for private companies to take control of the use of waters belonging to the people of the United States, it is vital that we hear from witnesses who can provide expert testimony on how taking authority away from other agencies and consolidating power and decision-making authority solely within the FERC might impact the public interest. Mr. Chairman, I want to thank you, and I yield back the balance of my time. Mr. McNerney, I want to
I thank the gentleman for yielding. While there are a number of bills under discussion today, I'm going to focus my remarks on hydropower. We know that worldwide, hydropower generates about 6% of electricity and about half of the renewable energy generation. Hydropower generation does not produce carbon emissions. As a nation, we must move away from harmful fossil fuels and continue to bolster our renewable and clean energy generation sources if we are to combat and mitigate the effects of climate change. We also know that FERC will manage approximately 500 hydropower projects by 2030 that represent about 18,000 megawatts of generation. The current process clearly needs improvement. So what is it that needs to be done? Accountability of all stakeholders, timely decisions, and the sharing of information, protection of our nation's waterways, habitat, and environment. Now, the Federal Power Act has worked okay in many ways over the last 90 years, but I've heard from stakeholders over the entire spectrum that the process could be better. I've heard from FERC, from the resource agencies, from applicants, from tribes, from states, from NGOs, and others. I believe that we can find common ground, but we need to work on a bipartisan basis to enact real solutions. If one side or the other imposes its will on the other, the solutions won't work. I yield back.
Gentleman yields back. The chair calls upon the gentleman from North Carolina, Mr. Hudson, for 3 minutes.
Thank you, Mr. Olson. I'd like to thank Chairman Upton and Ranking Member Rush for holding today's hearing on improving America's hydropower systems. This issue resonates strongly with me because North Carolina has a rich history of hydropower. Our Catawba River was among the first rivers to be developed for hydropower. In North Carolina alone, it generates enough electricity to power 350,000 homes each year. This low-risk, high-reward technology could provide significant benefits, yet the potential remains uncaptured, in part because of prohibitive permitting process. I'm pleased to continue working with my colleagues, Congresswoman DeGette, on promoting Small Conduit Hydropower Facilities Act to build on this committee's successful legislative efforts and reduce the total review process time for small-scale hydropower by 75% from 60 days down to 15 days. Reducing regulatory burdens is a common-sense way to increase our supply of clean and affordable electricity. Thank you again, Mr. Chairman, for including our legislation on today's agenda. I look forward to working with you to advance this initiative through the committee. And I yield back.
The gentleman yields back. The chair, now in the spirit of bipartisanship, calls on anyone from the Democrat side for a 3-minute statement, like Mr. Hudson. Oh, I didn't see Mr. Plone, I'm sorry. 5 minutes for the ranking member of the full committee, Mr. Plone.
Thank you. Thank you, Mr. Chairman, for holding the hearing on the 10 bills addressing hydropower and pipeline infrastructure. Hydroelectric power is among the most mature generating technologies. It provides virtually carbon-free baseload energy at low cost to our manufacturing sector and to residential and commercial consumers, and hydroelectric power is an important asset we need to maintain. At the same time, it has major impacts on fish and wildlife populations, water quality, water supply management, and other important physical and cultural resources if poorly operated or sited. While hydroelectric power licenses depend on rivers for free fuel, those rivers belong to all Americans, not just those who sell or buy the power generated from it. Hydroelectric licenses have fixed conditions that generally remain unchanged during the 30 to 50 years that they're in force. Licenses also benefit from unlimited automatic annual extensions after their license has expired if a new license has not been issued. And as a result, the impacts of these hydropower dams often go unaddressed for more than half a century. For those facilities first licensed before enactment of the National Environmental Policy Act, the Clean Water Act, and the Endangered Species Act in the 1970s, the licensing process certainly can be quite rigorous. Sometimes the necessity of addressing these complex issues also makes the process time-consuming and expensive, as new license conditions will require significant upgrades to old facilities to bring them in line with modern environmental laws and regulations. So, Mr. Chairman, we want to work with you on hydroelectric licensing reform with the goal of expediting the process while maintaining the fundamental principles of balance in the process. And this would allow us to maximize the benefits of hydroelectric power and expand it where it's most appropriate to do so. Our hydro hearing in March was one of the most constructive we had, and that was very encouraging. Yet it was also incomplete because we did not hear from the other stakeholders who were central to relicensing. We didn't hear from federal resource agencies, states, and tribes. And this is something members on our side feel strongly about, which is why we wrote to you. And you, Mr. Chairman, and Chairman Walden, last week, we wrote to you requesting a hearing because we understand more fully the challenges facing the hydropower industry and the rivers the industry relies upon before we update our policies. But we also gain a more thorough appreciation of the impacts of hydroelectric generation on others who use the rivers, tribes, fishermen, farmers, boaters, and many more to ensure their interests are treated fairly in the process. So I just wanted to turn my attention to the two non-hydro bills before us today. First, we have a discussion draft that amends the Natural Gas Act and resembles similar legislation we saw last Congress, as well as proposals in prior years. The purported goal of the draft is to enhance agency coordination and speed up FERC's review of natural gas pipelines. While I think we could all support the idea of making permitting more efficient generally, this bill, like its predecessors, remains a solution in search of a problem. The fact is that in the last 3 years, FERC has approved more pipelines each year than the one preceding it, with roughly 90% of pipeline projects being certificated within 1 year. And I will admit that since President Trump took office, the number of approvals has taken a dive, but that has nothing to do with the permitting process. Instead, approvals are down because FERC has lacked a quorum for 3 months, and the President has yet to nominate anyone to any of the 3 open slots. To make matters worse, FERC will soon have only one commissioner when Commissioner Honorable's term expires at the end of June. What that means in terms of natural gas projects is that FERC has not approved a gas pipeline project since February 3rd. So if the goal of my colleagues on the other side of the aisle is truly to speed up the FERC approval of gas pipelines, perhaps they should pick up the phone and ask President Trump to nominate at least a couple of new FERC commissioners so they can begin to consider applications for these projects once again. Until then, I find any conversation about needing legislation to expedite pipeline approvals at FERC untimely. The cross-border energy discussion draft also looks very similar to legislation we debated at length last Congress. This proposal eliminates the current presidential permitting process for energy projects that cross the U.S. border, substituting it with a weaker environmental review process that in effect rubber stamps applications. With President Trump already approving the Keystone XL pipeline and signaling support for new pipelines and other energy projects around the country, it's unclear to me why Republicans feel it's necessary to strip the president of his approval authority. Do my colleagues on the other side of the aisle honestly not have confidence in President Trump to make rational decisions on major energy projects? While I certainly have many concerns and would certainly not fault my Republican friends for any trepidation on their part, I still believe that this authority should continue to rest with the President of the United States, regardless of whether his name is Obama or Trump. So I want to thank our witnesses for coming today, particularly Ms. Danis, who is from New Jersey and is here representing, among others, the New Jersey Conservation Foundation. Thank you, Mr. Chairman.
The gentleman yields back. We now conclude with member opening statements. The chair would like to remind all members that pursuant to the committee rules, all members' opening statements will be made part of the record. And I want to thank our witnesses for being here today and taking your time to testify before the subcommittee. Today's hearing will consist of two panels. Each panel of witnesses will have the opportunity to give an opening statement followed by a round of questions from the members. Once we conclude the first panel, we'll take a few minutes to set up the second panel. Our first witness panel for today's hearing includes Mr. Terry Turpin. Mr. Turpin is Director of Office of Energy Projects at FERC, and Mr. John Katz. Mr. Katz is the Deputy Associate General Counsel for the Office of General Counsel at FERC as well. We appreciate you being here today. We'll begin by recognizing you, Mr. Turpin, for 5 minutes to give an opening statement.
Thank you. Good morning, Vice Chairman Olson, Ranking Member Rush, and members of the subcommittee. My name is Terry Turpin, and I am Director of the Office of Energy Projects at the Federal Energy Regulatory Commission. The office is responsible for taking a lead role in carrying out the Commission's duties in siting infrastructure projects, including non-federal hydropower projects, interstate natural gas facilities, and liquefied natural gas terminals. Thank you for the opportunity to appear before you to discuss drafts of the Promoting Interagency Coordination for Review of Natural Gas Pipelines Act and the Promoting Cross-Border Energy Infrastructure Act. As a member of the Commission's staff, the views I express in my testimony are my own, and not necessarily those of the Commission or any individual commissioner. The Commission is responsible under Section 7 of the Natural Gas Act for authorizing the construction of interstate natural gas facilities, and under Section 3 of the Natural Gas Act for authorizing the construction of import-export facilities. The Commission acts as the lead agency for the purposes of coordinating all applicable federal authorizations and as the lead agency for complying with the National Environmental Policy Act. The environmental review is carried out through a process that allows cooperation from numerous stakeholders, including federal, state, and local agencies, Native Americans, and the public. In order to maximize the engagement between the applicant and these various stakeholders, the Commission has developed its pre-filing review process. The Commission's current approach allows for a systematic and collaborative process and has resulted in substantial additions to the nation's natural gas infrastructure. Since 2000, the Commission has authorized nearly 18,000 miles of interstate natural gas pipeline, totaling more than 159 billion cubic feet per day of transportation capacity, over 1 trillion cubic feet of interstate natural gas storage, and 23 facility sites for the import or export of LNG. Over the past 10 years, the Commission has also issued 15 authorizations related to natural gas border crossing facilities. These results have been facilitated through the environmental analysis under the National Environmental Policy Act, which I believe has been improved through the Commission's approach through the pre-filing review phase of the project. Regarding the discussion drafts, I note that many of the comments of previous office directors have been incorporated on similar past proposals and have been incorporated into these versions. As I explained in my testimony, the discussion draft on interagency coordination would alter the Natural Gas Act to include many of the existing practices the Commission currently uses successfully in its review process. The discussion draft addressing cross-border energy infrastructure would add oil pipeline border crossings to the Commission's jurisdiction and would remove requirements for presidential permits for both oil and natural gas border crossings. Staff already has substantial expertise in analyzing natural gas pipeline border crossings, and this could be extended to oil crossings under the final rules the Commission would be required to issue. This concludes my remarks on the discussion drafts addressing interagency coordination and cross-border infrastructure. Commission staff would be happy to provide technical assistance as you move forward with your consideration of this legislation. I will be pleased to answer any questions you may have. Thank you.
Mr. Turpin, thank you very much. The chair now calls upon Mr. Katz. You're recognized now for 5 minutes for an opening statement.
Thank you, Mr. Chairman, Ranking Member Rush, members of the committee. It's a pleasure to be here before you today, and thank you for the invitation to testify. My name is John Katz. I am a member of the staff of the Federal Energy Regulatory Commission, and as such, my comments represent my own opinions and not necessarily those of the Commission or of any individual commissioner. I'm going to focus on the bills that involve hydro aspects. The Commission regulates over 1,600 hydro projects, which involve more than 2,500 dams. The production of these hydro projects is some 56 gigawatts, which is over half of the hydro capacity of the United States. The United States does a little bit better than the figure Mr. McInerney quoted for the world. Hydro is 8% of U.S. capacity. Hydro is a renewable resource. It affects many other resources, including irrigation, flood control, water supply, fish and wildlife, and recreation. And these are matters that Congress has asked the Commission to balance when it issues licenses. The key thing in getting a hydro project licensed quickly is probably site selection. This is a matter within the control of the developers, so good development is what's going to carry the day, not the government, not the other interested parties. The community needs to be involved. Stakeholder involvement is very key. Issues need to be identified early, and developers need to work with the community and stakeholders to try and resolve matters so that things can be done in a quick manner. A good example of this is the 400 megawatt Gordon Butte project. It's a pump storage project in Montana. That project was licensed in 14 months. And the developer of that project recently appeared at a workshop at the Commission, and while on the one hand he was very complimentary of the efforts of Commission staff, he said that the key to getting it done in time was that the Commission had essentially turned him loose to allow him to develop a process that worked for him and his stakeholders, and that is something that the Commission does on a regular basis. The Commission does its best to be efficient and effective. Since 2003, the Commission's issued 82 original licenses, and of those, about 25% have been licensed in 2 years or less, with about a 1.4-year median processing time at the Commission. Congress has done a lot to help the Commission in carrying out its job. In the 2013 Hydropower Regulatory Efficiency Act, Congress provided that certain qualifying conduit projects could be completely exempt from Commission regulation. The Commission has approved or signed off on 83 of those projects since then. Congress also allowed the Commission to consider small projects at an increased level. They used to be limited to 5 megawatts, and Congress increased that to 10 megawatts. There have been 7 such projects filed since the passage of that act. Finally, Congress allowed the Commission to extend the time of preliminary permits, which are what an applicant gets to study a project, and the Commission has approved 57 extensions of permits since that time. Commission staff supports the goals of the legislation before you to the extent that they improve efficiency, enable the development of new infrastructure, support balanced decision-making, and reduce duplicative oversight. We are concerned only to the extent that additional bureaucracy is added to the process. Commission staff and other agencies are not, in my experience, looking to do additional processes or things that will slow down development, but rather want to pare back these processes to the extent we possibly can. Finally, I want to note that there are several bills that provide extensions of the commencement of construction deadlines for certain projects, and those bills are all consistent with Commission policy. Thank you very much, and I'd be happy to answer any questions you may have.
Thank you, Mr. Katz, for your testimony, and we'll now move to the question and answer session of the hearing. I'll begin the questioning by recognizing myself for 5 minutes. Again, welcome Mr. Turpin and Mr. Katz from Texas 22. I am very concerned about the lack of a quorum at FERC and the negative impact it could have on pending pipeline projects. The administration and the Senate have to make this a priority. My question is, how is the Commission handling the workload? What types of actions have been delegated to staff which require sign-off from the commissioners? Mr. Turpin?
Thank you. The workload, in a large part, for the things that are delegated, such as the NEPA reviews and the processing applications, continues unabated. Staff is working as hard as it ever has, even when there was the quorum. There are issues related to gas projects where the offices don't have a lot of delegated authority, and staff is preparing those drafts for consideration when there is a quorum. And on the hydro side, there's a bit more delegated authority, and there are more orders and decisions that can be made on uncontested cases.
Thank you, sir. Another question for you, Mr. Turpin. A few years ago, the GAO analyzed major pipeline projects. They found that you can take up to 2.5 years for a FERC certificate. It averaged 568 days. I actually asked about this study in a hearing last Congress. So if you haven't read the study, that report recently, I'd like to know, one, even if you haven't, what are the biggest sources of friction there are for pipeline approval? And number two, what have you all changed in recent years to make this process faster?
I haven't read that study. In looking back at the data for all issuances for the Commission since 2009, on average, it's 88% of the projects get issued within 1 year. Of course, that encompasses a lot of the projects that are very small in scope and therefore move faster. The larger and more complex a project, the more time it tends to take, just as a function of the higher number of stakeholders that are engaged and the more complex issues that are raised. In terms of what are the points of friction, in general, really it's the development of the information. As Mr. Katz alluded to with hydro, site selection on that is a major determining factor, and it's the same for pipelines. The route selection is a very large factor, and which is why the Commission had developed the pre-filing process. It allows the applicants to come in and engage the stakeholders well before they've sort of finalized the route to get input on where the best route may be that addresses all the issues. And that allows them then, once they do file the application, to move forward. But it is the development of that information along the route as well as the information related to the construction and design of the facilities that usually are the stumbling block for the regulating agencies.
Thank you. And Mr. Katz, I'm not going to leave you out of the questioning. What are the opportunities to expand the nation's hydropower capacity? Specifically, what's the greatest impediment to installing power generators on non-powered dams?
I think there are significant opportunities, and I think, as you alluded to, the greatest opportunities, or at least the simplest opportunities, are adding capacity to non-powered dams, including government dams, those operated by the Bureau of Reclamation and the Army Corps of Engineers. I think that the greatest impediment to that are failures to obtain consensus among the various stakeholders, where people are comfortable. And for example, we've recently licensed a project in Pennsylvania where everybody was very comfortable with the project. They felt it was good for the environment and good for the energy distribution in the area, and that was able to go through very quickly. Where you have stakeholders who are not comfortable and raise issues, whether it's state agencies, federal agencies, or other entities, that can slow down the process radically.
Further question, what types of technologies are being developed to improve safety, efficiency, and lessen the environmental impact of hydropower? And what can Congress do to help further innovation?
I'm not an engineer, so I'm not expert in the types, but I know there are...
Me neither.
Mr. Turpin knows more about engineering generally than I do, but I think Mr. Leahy and perhaps some of the witnesses who come later may be able to give you more detail, but I know that there is development ongoing, some of which has been funded by the Department of Energy to help develop fish-friendly turbines and other types. There's one new project that is using what's called an Archimedes screw technology, which is brand new. Folks have been looking into wave and tidal energy projects. These are all new, promising technologies that can continue to be explored.
Thank you. My time has expired. Now I call upon the ranking member of the subcommittee, Mr. Rush, for 5 minutes.
I want to thank you, Mr. Chairman. Director Turpin, a recurring theme in all of these bills is that the environmental protection concerns are given a back seat in order to expedite applications for both natural gas pipelines and hydropower licenses. In your opinion, does FERC staff have the necessary expertise to determine the scope of environmental review needed to satisfy NEPA obligations for natural gas permits?
Thank you, sir. I think for the purposes of determining the Commission's NEPA obligations, yes, Commission staff is well-versed in that. We have a large staff in the Office of Energy Projects that are archaeologists, engineers, biologists, environmental protection specialists, and with that staff, we can very well do that job for the FERC's needs. However, the NEPA, even though NEPA applies to all federal agencies, being a process-based statute is the process we all have to comply with, but different agencies with other jurisdictions might have different obligations or jurisdictional coverage, and FERC staff is not versed in those statutes for other agencies.
Well, in regards to hydropower licensing, does FERC have any statutory mandate to protect water quality, wildlife, or access to public lands, as in the case for some of the other agencies that are made subordinate to FERC with this bill?
The Commission has the obligation under the Part 1 of the Federal Power Act to consider all aspects of the public interest. Did I answer your question, sir?
No, it doesn't.
I'm sorry?
It does not. Do you have any statutory mandates?
Yes, we do. The Federal Power Act requires the Commission to consider all aspects of the public interest.
All right, Mr. Turpin, in your opinion, does FERC currently work effectively with the other agencies throughout the natural gas application process? And would altering FERC's role from one of collaboration with other agencies to, quote, policeman, in a, quote, role of overseeing and monitoring other agencies' congressionally mandated duties to improve coordination and will this result in faster application decisions?
As noted in my testimony, I think the FERC pre-filing process is collaborative. We engage a lot of agencies. It's the whole point of the approach. And I think we're very effective at doing that. Most agencies are very willing to participate and to engage with staff, but they have their own resource constraints. They have their own statutes they have to meet, and it is those that drive their needs more so than the Commission's schedule that's put out.
Well, the extension of that question is, are there ever instances of a natural gas permitting application being delayed because an applicant has not submitted all of the necessary information? And if so, how would this legislation help expedite the process in those cases where agencies are not provided with timely and complete information necessary to perform congressionally mandated project reviews? And if you have any recommendations I'd like to hear them in order to address this issue.
The best thing in terms of generating the information is the early engagement of all the stakeholders. The earlier agencies can get involved and define what information needs they might need for their mandates, the better, because that gives the applicant enough time to go out and find that info, develop those studies. So, the pre-filing process allows that. The legislation encourages that same early engagement, and I think that's the best path forward for trying to address those issues.
Thank you, Mr. Chairman. I yield back.
The gentleman yields back. The chair now calls upon the gentleman from Ohio, Mr. Latta, for 5 minutes.
Well, thanks, Mr. Chairman, and thank you very much to our witnesses for appearing before us today. Mr. Katz, if I could ask maybe a follow-up from your earlier statement. You had mentioned that there was a project out in Montana that was a hydro project, and that there's also, because of the area where it was and with the selection of the site, that I believe that you said that the individual said that they were turned loose to get this project done. How often does that happen, that folks out there can actually do something like that? And when they say get turned loose, how fast can that happen in in the permitting and everything else to get a project done?
Sure. It's hard to give an exact time because it really depends on what information is provided and what the issues are. What I meant by that was the Commission has 3 licensing processes. 2 of them, the integrated licensing process and the traditional license process, have fairly specific time frames and details of things you have to do. There's another process called the alternative licensing process, which allows the stakeholders to essentially set up their own licensing process the way they want to do it, and the Commission is always open to allowing people to do that if that's something that they can agree upon. Okay. And in this instance, the developer was very forward-looking and positive and took the reins in his own hands and got a lot done very quickly.
So how often can someone do that alternative? Does that occur is that very frequent, infrequent?
It is less frequent than the other 2 processes, but it's always available. I think it's a question of what the parties think will work best. For example, the traditional process tends to work best for smaller projects because it sets forth more exact deadlines, but has less of the collaborative sort of going out there and meeting and doing a lot of stakeholder involvement, and so it can be less expensive and easier for smaller projects and those by developers with less funding. The alternative process, however, can be shaped in any way that the stakeholders think is appropriate, provided that they give the Commission a complete record at the end of the day, and in the Gordon Butte case, that's exactly what they did.
Okay, let me follow up with you again, Mr. Katz. How do the permitting timelines for hydropower compare to other types of renewable energy developments, such as wind and solar projects?
I think they're significantly longer.
Do you believe that the permitting process could be improved to level that playing field, and how?
Absolutely.
Okay, and how would that be permitted? How would we level that playing field?
I don't have exact prescriptions. I think some of the things in the legislation before us would go a ways toward doing that. Whatever we can do to reduce duplication and to get everyone on the same page at the same time will help. What tends to slow things down are if one agency is not finished at the same time another agency is, or if it feels it needs to do additional environmental work or other things, so that then things are not sequential, but rather, or things are sequential, I'm sorry, rather than being done at the same time. To the extent it can be one process that is run in an orderly and efficient manner, that will cut down the time.
Would you say there's a lot of duplication in a federal process then, between agencies that have that duplication?
There is some, yes.
Let me ask also, not to pick on you, Mr. Katz, when there are disputes about a potential condition, the licensing stakeholders are entitled to a trial-type hearings on the facts and the evidence. It's clear that the current process under the Federal Power Act has not worked as it has been intended. It requires so much time, money, and staff resources, it's rarely used, if ever. How many types of these trial-type hearings have been conducted to your knowledge?
Again, Mr. Leahy may know exactly. I suspect he does. To my knowledge, it's in the area of 5 or 6. It's not a lot. Those are not conducted before the Commission. To this point, they've been conducted before administrative law judges designated by the agencies that impose the mandatory conditions that are the subject of the hearing, so the Commission doesn't have detailed knowledge about them.
When you say 5 or 6, is that 5 or 6 a year or 5 or 6 over time?
I think total, again, I'd hesitate to look over at Mr. Leahy. He'll know the number, but it's not a large number.
Okay. And then the Commissioner is responsible for assessing whether it would be responsible to include conditions in the project license. Shouldn't the Commission take the lead with these trial-type hearings?
It is possible. The bottom line, though, is that those conditions are mandatory, and the Commission has no authority to not include them in the license, so question whether the trial-type hearings do anything that the Commission can act upon at the end of the day, because as long as they're mandatory, whether the trial's at the Commission or not, it doesn't change the result.
Thank you very much. And Mr. Chairman, my time's expired, and I yield back.
The gentleman yields back. The chair now calls upon the gentleman from California, Mr. McNerney, for 5 minutes.
Well, I think the chairman, Mr. Katz, California and the FERC entered into a memorandum of understanding regarding hydropower. Can you point to any significant benefits that have resulted from this MOU as it relates to hydropower licensing and relicensing?
I think that the efforts there were made to sort of process things in a sequential time. I know California has had budgetary difficulties, so that the state agencies have not had the resources that they would like to be able to devote to all of the hydro projects, and the sense, I think, of the MOU was to get things done in an orderly and sequential fashion. I think it has done some good in that regard.
So it's mostly to benefit the state processes?
Yes, I think so. I mean,
Well,
it also, I believe the MOU called upon, to the extent possible, for the environmental reviews of the state and the commission to be sequential, or I'm sorry, I keep saying sequential, to be done at the same time, and for California to not have to do extra work at the end of the day, but ultimately that's a call for the state to make.
Okay, you did use the word sequential before, so you meant concurrent.
Exactly, in this instance, yes. Concurrent
makes more
reviews are
sense.
always more efficient than sequential reviews.
So FERC currently attempts to complete studies on a concurrent basis. The Hydropower Modernization Act draft language more or less requires concurrent studies prior to or in concurrent with preparation of the FERC environmental requirements from the NEPA. Is this a good approach, or what is the best approach we can take to get concurrent studies?
I think it's a reasonable approach. The bottom line is, however, that both as to state agencies and other federal agencies, they have their statutory mandates which they need to satisfy, and there's nothing in the current Federal Power Act or in the draft legislation that would preclude those agencies from taking the time they need and from performing additional reviews if that's what they feel they need to satisfy their statutory mandates.
So you feel that concurrent requirements aren't going to throw environmental protections aside or blunt them to some degree?
I did not see anything in the idea of concurrent reviews that would undercut environmental protection.
What other areas of improvement under the integrated licensing process?
I'm sorry, could you ask the question again?
What are areas of improvement under the ILP?
There's probably a variety of improvements. I think mainly they involve on-the-ground aspects rather than necessarily regulatory or statutory changes. I think getting people on the same page and getting them to reach agreement on what sort of studies need to be done and what the work is that's necessary to develop a full understanding of a hydro project is key. And in some instances, folks reach that agreement and proceed very quickly. In other instances, they greatly disagree, and I'm not sure that there's really much that can be done by statute or regulation to force people who have different statutory authorities to agree.
Okay. How often do the licensees have to utilize the FPA's authority for automatic year-to-year license extensions?
It's not a question of something that a licensee can use. What the statute provides is that if a license expires and the commission has not yet been able to issue a new license, then what's called an annual license is automatically issued. And I can't give you a percentage. I'd be glad to get that information back to you if you want it, but it's not unusual.
Moving on. I've heard from a lot of stakeholders who say that agencies can improve with information sharing. Could you describe the information sharing process as it relates to the study process?
Sure. I mean, the commission believes in a very transparent and open process. There is no secret information on hydro projects. As studies are done, they are filed with the commission. They're available to all stakeholders. Often there are study review meetings under the ILP, for example, where everybody sits down and goes over the study, discusses its merits, its demerits, whether there's further information done. So transparency is an absolute key to the hydro licensing process.
Well, could there be any value to having stakeholders support a person-to-person type manager dedicated to particular basins throughout the country to facilitate the processes?
I am not certain about that. I'd have to know more about the proposal.
Okay. All right, my time's expired, Mr. Chairman. I'll yield back.
Gentleman is back. The chair now calls upon the gentleman from Pennsylvania, Dr. Murphy, for 5 minutes.
Thank you, Mr. Chairman. Mr. Turpin, the Natural Gas Act requires the commission review whether proposed interstate pipeline is necessary or desirable in the public interest. The law also requires the commission to set rates charged for interstate pipeline service to be just and reasonable. So let me ask another area here. Does the commission take into account jobs and economic impact as it reviews the public interest?
Well, the criteria that the commission considers, and it is a decision by the when there's 5 sitting commissioners, are laid out in the 1999 certificate policy statement. My office is really focused on generating the environmental impacts associated with a construction of a project, and in gathering the data from the application that the applicants put forward on justifying that.
But are jobs considered all impact upon employment?
I can't say what each individual commissioner considers.
What about you?
I don't have a say in that. I generate the information and I pass. The NEPA document is not a decisional document.
But in terms of the information generated, you don't put down impact upon jobs, employment, those things?
There are, in the NEPA document, there's socioeconomic analysis that looks at construction jobs, looks at impacts to the area for lodging, traffic, for those localized impacts.
Okay, thank you. How often has the Commission used its authority under Section 5 of the natural gas sector to review the rates and require prospective changes when the rates are no longer just and reasonable?
Sure.
The Commission does not often do that. The Commission has in recent years proposed to look at a couple of pipelines under Section 5, but it's not something that occurs very often.
Why is that?
I think the Commission has not seen instances where pipelines appear to be charging excessive rates. Certainly if people complain about it and come before the Commission and say, you need to look at this pipeline rate because it's excessive, that's something Commission staff would look at. As I said, that's not Terry and my area of expertise, but I'm not aware that it occurs very often.
Are you aware, in your areas of expertise, looking at any of the things of impact, economic impact and employment issues too?
If you're asking me, as Terry said, yes, the Commission looks at all the information that's provided to it in a case, so if information is regarded required or concerning increased employment, yes, the Commission would have that information before it to consider.
If it's there, you're saying?
Yes, I mean, the Commission is not in the best position to determine how many people a pipeline company is going to hire. The company's in the best position to know that, and if it provides that type of information to the Commission, then it is in the record for Commission consideration.
But that is not something you necessarily request? If they provide it, you have it. If they don't, you don't?
I am not aware of the Commission specifically requesting that.
So what I'm concerned about here is of course, that these are jobs. They're good-paying jobs, and people are building pipelines, whether they are the engineers, the operating engineers, the welders, whatever that might be. Those are pretty valuable jobs and have an initial impact upon employment. Longer term, obviously, then it's maintenance of the pipeline, but the same thing for hydroelectric power, too. I mean, we look at those things as important to make sure we're reviewing those. Well, it's something that I believe we should be looking at as well, and hope we can get to that future. Mr. Chairman, I'll hold off with other questions for now and wait for the next panel. Thank you. I yield back.
The gentleman is back. The chair now calls upon the gentleman from California, Mr. Peters, for 5 minutes.
Thank you, Mr. Chairman. Thank you very much for being here. You know, as someone who, one of the reasons I ran for Congress was to deal with climate change. And I'm excited to be on this committee. I'm new to it. I don't understand why more people on our side of the aisle aren't flipping out about how long it's taken to do hydro. It's one base load that's carbon-free, and I'm interested in understanding kind of what the obstacles are. Let me say that one thing that I thought was interesting about your response to the chairman about what the obstacles are, Mr. Katz, is that you talked about stakeholders, not environmental issues, and that the obstacle was getting stakeholders to agree. In my mind, as a former environmental attorney, that's an extremely subjective kind of standard to try to reach. It's something that can vary greatly depending on the group of people you get in the room. And it's also something that's got to scare the heck out of investors who are looking for some sort of certainty at the end of the day. I'm not going to be able to, I'm just really interested in working the problem. And again, I'm not going to be able to do that in my 3 minutes and 49 seconds with you. But I just would say that it seems to me that maybe we could identify some more objective criteria so that we protect rivers, we protect fish and wildlife, but in a way that's more objective. And I think that would help us just instinctively. It seems to me that would help us save some time. One thing you did say about, in reaction to some of the materials before us, is that you're concerned that some of it would add bureaucracy. And I would like to know now what in here would actually add to the bureaucracy. What is your concern that might actually slow us down?
Sure, and let me say in addition, in response to your initial comments, that I think it's difficult to have objective environmental criteria since every hydro site is different, but I agree with you that being as objective as you can is a good goal. And one of the things in the hydro area is that there's what we tend to call shared decision-making. So this is not a matter where the commission gets a hydro proposal, it reviews it, it approves it or doesn't approve it, and it's done. There are instances where other federal agencies have the right to impose mandatory conditions. The states have the right to impose mandatory conditions under the Clean Water Act. So those are the things when I talk about the stakeholders include those agencies that have a right to participate in the proceeding and to affect the ultimate licensing, and it's really necessary to get them on the same page to be effective. Now, in terms of the specifics of the act, be glad to work with you and your staff on those in the future. Some of the things, for example, one of the things that struck Commission staff in looking at these were the provisions regarding amendments. And the provisions there seem to require for all amendments that there be a schedule established and perhaps a memorandum of understanding undergone. And it's been Commission staff's experience that 87% of amendments are approved within 6 months because they're usually minor matters. So while the provisions regarding the process might very well be very useful for larger, what we call capacity amendments, where someone is greatly increasing the capacity of a project, they would not necessarily be helpful in terms of the smaller work. So it's those sorts of things where everything is not one size fits all, and we'd want to be sure that whatever processes are created will be applied to those proceedings in which it makes them quicker, but would not be applied to those proceedings in which it would slow them down.
Let me just ask one other specific question. Is there a way we could speed up the relicensing of existing facilities that may be wearing out? Is there some reason why that takes as long as it does?
I honestly don't have a magic answer. I don't know that anyone else does, or it would have been done long since. I know Congress, all of the stakeholders have been concerned about this for years. I think part of the problem is just the statutory structure where you need to do a thorough environmental review, and then there are a number of authorities that have the right to impose conditions. It's very hard to do a set process. For example, under the Clean Water Act, the Commission can't issue a license unless it's gotten either waiver of certification or a certification from the states. And there are some instances where the Commission has been completely done its work on a project and has been sitting for more than a decade waiting for a state to act under the Clean Water Act, and there's just flatly nothing the Commission can do about that.
Right, I understand.
Ours could change that if it wanted. But
I was going to say, fortunately, we're talking about statutory authority right here in this room, so you're probably talking to the right people. And I appreciate the constraints that the Commission has, and your answers have been very helpful to me. Mr. Chairman, thanks for the hearing, and I yield back.
The gentleman yields back. The chair now calls upon the gentleman from Mississippi, Mr. Harper, for 5 minutes.
Thank you, Mr. Chairman, and thanks to you both being here, and look forward to additional info on this very important issue. Mr. Katz, if I can ask you a couple of questions. You know, the ownership and regulatory environment for hydro is very complex. Where do you see the greatest opportunities for streamlining the process to improve that transparency and efficiency?
Again, I think that the greatest opportunities are making all decision-making as concurrent as possible. Anytime you get into sequential decision-making, it slows things down, often radically so.
Okay, can you identify a place or places where you see the greatest amount of duplicative or unnecessary work? Is there something that comes to mind?
I can't say as sort of an across-the-board matter, but some states and some agencies, in some cases, decide that they need to do their own environmental review in addition to what the Commission does, and that can take time. Also, some of those entities do not time their decision-making so that it syncs up with when the Commission's ready to act, and those matters can radically delay.
Would it help, Mr. Katz, if to have FERC act as a lead agency to maybe issue a schedule and enforce deadlines?
Sort of the devil is in the details. I mean, the Commission always is the lead agency, sure. And the Commission's regulations and in given cases, specific orders do set schedules. It's the enforcing the schedules that's hard. And that's kind of a two-edged sword, because on the one hand, the Commission might like to be able to say, you will hand in your state authorization by date X. At the same time, the states have sovereignty, and to the extent that they are told they need to do something by a certain time, if they feel not ready, they could always deny certification or load up on very burdensome conditions because they felt they didn't have the time necessary to do their job. So it's a real difficult chicken and egg problem.
And do you wind up with a lot of conflict in those situations where that happens on a regular occasion?
I don't know if it's open conflict. You know, maybe it's more like the Cold War. I know, again, I hate to keep deferring to Mr. Leahy, but I think he will tell you that there are licensees that are very frustrated because they've done all that they can, and in many instances are satisfied that the commission has done all it can, but projects are not ready to go forward because other entities are not ready to act.
And those other entities would be state entities?
Some state entities, sometimes it's other federal agencies.
Okay. Which, if we were trying to decide between the two, would it be primarily more responsibility on state agencies or other federal agencies that you see just in generalities?
That's hard to say. I would suspect that Clean Water Act certifications are the greatest instance of delay, but Endangered Species Act consultation also delays a number of projects.
You know, almost everybody would agree that, you know, hydropower is it's clean, renewable, abundant, and I believe affordable. What many people don't realize is that it does also improve the reliability of the electric grid. How does hydro help integrate intermittent renewables like wind and solar?
Hydro can play a very significant role in doing that because hydro has what's called black start capacity, so you can have the hydro sitting there and it turns on instantly as soon as you let the water flow and turn the turbines. So when you're pairing it with something like wind, which is intermittent, it can play a major role in balancing the grid.
Well, how about when there's an outage? Does hydro do the same to bring the grid back online?
Yes, it can serve in that capacity as well.
Right. And how does hydro compare to other energy sources in terms of its environmental impact?
Well, that's a subjective matter, but as a general matter, it is carbon neutral, so it does not have air quality impacts. There are those who are concerned about the impacts on aquatic resources, but with proper management and proper conditioning, hydro can be a very benign resource.
So what would you say, Mr. Katz, what the greatest impediment to attracting capital to invest in new hydropower projects, what would that be?
Again, that's not my area of expertise so much as it is the industry, but I would say uncertainty and the time the licensing process takes.
Okay, great. With that, I'll yield back, Mr. Chairman.
The gentleman yields back. The chair now calls upon the gentleman from Texas, Mr. Green, for 5 minutes.
Thank you, Mr. Chairman and Ranking Member, and I want to thank our witnesses for being here. Mr. Turpin, it's clear from today's hearing that FERC has a whole lot on your plate. And currently, pipelines, LNG permitting, hydropower, electric reliability all fall under FERC. In addition, there are many in the House who would like to expand FERC's permitting authorities to include oil pipelines. In your position as the Director of the Office of Energy Projects, most of these fall within your office. If FERC, Mr. Turpin, if FERC receives a request for a natural gas pipeline permit within the United States, could you please describe the review process to receive a certificate of public necessity?
Sure. For a line of any length, if it's especially a complex or a large scope, we would encourage the applicant to follow the pre-filing process. It is voluntary for pipelines. During that process, the Commission staff would try to engage the other agencies and stakeholders.
What other agencies is it on the federal level?
Any federal agency, any agencies issuing a federal permit, whether that's a federal agency or a state agency acting on federally delegated authority. We would also reach out to state and local agencies to bring them into the process as well. The idea is to get as many folks under the tent at the beginning of the process when the applicant is still trying to design the route, rather than wait, and by that have the greatest influence on easy changes to accommodate all the issues, rather than wait until the applicant spent a significant amount of time and money in coming up with a project that then is harder to change. So that process at a minimum can take 6 months, but it really is set by the applicant. As long as they want to stay in pre-filing, they can. Once that, and during that pre-filing process, staff would engage in its environmental scoping processes and would be seeking comment from the public and any interested stakeholder about what environmental issues need to be addressed in looking at the project. Those issues are to be addressed by the applicant in 13 resource reports that must be filed with the commission. Each of the reports covers a different resource area, such as water quality.
But FERC's responsible for doing the National Environmental Policy Act in enforcement. Is that correct, NEPA?
We're the lead agency for constructing the NEPA document, yes,
Okay.
sir.
What about when it crosses a U.S. border, Mexico, Canada?
It is the same. Pre-filing likely would not be used in those cases because they're usually smaller scope projects.
Does FERC coordinate with the Department of State or Department of Defense when issuing a cross-border natural gas pipeline?
Currently, yes. The commission reaches out to both of those agencies to get their concurrence that there's not a national security interest.
If FERC were granted the authority to permit oil pipelines, would the commission follow similar procedures?
I think that would be determined by the commission. They will have to set the policies that my office would follow. We do have the existing program that we do for natural gas, so a good guess is that it would parallel that, but again, that would be set by the commission.
Does the Office of Energy Projects possess the resources to handle that additional responsibility and activity, and do you anticipate additional needs if you permitted oil pipelines?
We do have the expertise, we do have the staff. They haven't been a tremendous amount of those border crossings. As I said in my testimony, I think since over the last 10 years, we've done 15. I had staff look at potentially how many oil crossings there might be. I think we found there's somewhere in the neighborhood of 20 to 30 existing ones. So I don't think it's a tremendous workload. I think we would have to have some additional expertise for the unique aspects that are different from natural gas lines.
Oftentimes that oil pipeline's in the same easement that a natural gas pipeline or some other product. Mr. Katz, connected action has been legally defined as an action that's interdependent parts of a larger action. Mr. Katz, under NEPA regulations, FERC is required to review connected actions of pipeline project. Is that correct?
That is correct.
If a cross-border pipeline project cannot proceed without a certificate of crossing as described in the legislation, would FERC consider this a connected action?
Connected to what, sir?
If a cross-border pipeline project cannot proceed without a certificate of crossing as described in this legislation we're considering, would FERC consider this a connected action?
It could be a connected action to the remainder of the oil pipeline, yes.
Is FERC required to consider the cumulative impacts of a pipeline project?
Yes, it is, of all projects it reviews.
Okay. I'm out of time, and thank you, Mr. Chairman, but obviously coming from Texas, we are trying to sell as much natural gas as we can to northern Mexico, and I know there are processes now that are in place, and but again, crossing the international borders presents other issues, and that's what this legislation is about. Thank you, Mr. Chairman.
The gentleman's time has expired. The chair now calls upon the gentleman from West Virginia, Mr. McKinley, for 5 minutes.
Thank you very much, Mr. Chairman, for scheduling this meeting. Mr. Katz, if I could go quickly with you, I want to spend more time with Mr. Turbin. But do you think in your opinion, with the HR 446, 447, and 2122 that we're going to be talking about today, for the construction of hydroelectric projects in Virginia and West Virginia, do you think the Commission has any problem with getting additional flexibility so that it doesn't take an act of Congress?
No, one of the bills before you indeed would give the Commission the authority to extend the commencement of construction deadline, and I think I indicated in my testimony that Commission staff supports that concept.
Thank you. Mr. Turbin, I want to take a larger view, maybe perhaps take it from 30,000 feet on this issue of permitting, because I know from the testimony and what we've read that FERC has a responsibility to coordinate these projects in the timeline, but the agencies often break from the mold, and so it drags out. I'm trying to understand if we're moving in the right direction with this, because if we look back over it now, that over time we've developed now there are 15 different permits have to be achieved to build a pipeline from 10 different agencies, and the timeline for each of those agencies can be as long as 2 years or longer if they should so choose to do that. But we're talking just of those We have the FERC transporter, the FERC Certificate of Public Convenience, the Pipeline Hazardous Material Safety Administration permit, NEPA's EPA permit, the Army Corps dredge permit, the Section 10 permit, the right-of-way permit for the Army Corps, the federal levy right-of-way permit, the Fish and Wildlife incidental take permit, the Fish and Wildlife right-of-way, the Bureau of Land Management right-of-way, the Bureau of Indian Affairs right-of-way, the U.S. Forest Service public use permit, the U.S. Department of Agriculture easement, the Bureau of Land Reclamation. All of these, I guess what I'm wondering, are we really better off for having these permits? Because we look back at the track record when they built Hoover Dam, the permitting was less than 2 years to accomplish. And I wonder whether or not, did we cause havoc to the people in Colorado and along the Colorado River by building the Hoover Dam? The Alaskan Pipelines now have been 9 years trying to get a permit because in addition to these 15 permits, we've seen politics come into play with this. The Trans-Alaska Pipeline, as controversial as that might be, it took less than 1 year to get the permit. And now we have the advantages that occurred. So I'm saying, with all this progress process of additional paperwork, are we better off for it? Can you tell me from FERC that we've improved the system by delaying projects for 10, 15 years to do this? Think what I just said about the Hoover Dam. The permit was less than 2 years, but for 10 years, we're trying to build a low-head dam in West Virginia, and we can't get the permit after 10 years. Who's right? Were the people back in the 40s and 50s and 60s and 70s, were they smarter than we? That's you, Mr. Turbin.
Thanks. I think a lot of that depends on the perspective. I mean, all these agencies, all those permits, many of which that you read are actually crossing of federal lands, and that's the easement that the pipeline company must get. All have come about through congressional action. I think it's whatever, Congress directs these agencies at what they need to execute, and we execute on what we're told.
So in your opinion, Mr. Turp, are we moving in the right direction? I'm sorry to keep pinning. Are we moving in the right direction by adding delays? Because from construction, I spent 50 years in the private sector. Delays cost money. The time value of money, when you start something that maybe takes $10 million, even they're saying the licensing process for a new hydropower development project can last over a decade, and with costs over tens of millions of dollars. Are we better off for doing it that way? Or should we rely on the courts to see that they're upheld and let the construction begin? Because if we're truly after construction, we're trying to get jobs for people, wouldn't it be better to put them to work or to use paperwork? Who's benefiting from this? The unelected bureaucrats in Washington?
It certainly doesn't feel like a benefit to us. I think the answer is that it depends on what Congress determines is in the public interest. I mean, the bureaucrats have to execute the laws that are passed.
Thank you very much. I yield back my time.
The gentleman yields back. The chair now calls upon the star center fielder of the Congressional Women's Softball Team, Miss Castor, for 5 minutes.
That's right. The third week in June, the Congressional Women's Softball game against the evil women of the press corps. Mark it down on your calendars.
That's fake
but
news.
Thank you, Mr. Chairman, for calling the hearing today. One of the bills before us today aims to expedite FERC review of natural gas pipelines. Roughly 90% of FERC natural gas pipeline projects receive their certificate within 1 year, but nevertheless, I do understand that it's important to promote efficiency in all government review processes. But this is why just a year and a half ago, the Congress passed an important part of the FAST Act, and I had to go back and remind myself of all of this, and I encourage my colleagues to do the same. The FAST Act set up a new entity, the Federal Permitting Improvement Steering Council, FIPSE, to bring federal agencies together, including many that have been mentioned today, the Army Corps of Engineers, the Bureau of Land Management, Fish and Wildlife, to improve timeliness, predictability, and transparency of federal environmental review and authorization projects for major infrastructure projects, which includes interstate natural gas pipelines. The council spent 2016 getting off the ground and is now overseeing permitting for 32 major infrastructure projects, including 7 interstate natural gas pipeline projects. These projects will benefit from enhanced coordination, including establishment of a lead agency for the project, the establishment of recommended performance schedules and project review timelines, and greater transparency at all levels. In fact, the Business Roundtable just wrote a letter recently to the White House to say, can we move forward with getting FIPSI off and moving? I think it's still waiting for another appointment. So it's a bit confounding why we're here discussing an entirely new scheme for review of natural gas pipelines when we recently set up an entirely new entity to do just that. And at a minimum, we should have FIPSI here to testify about their progress, and I'd respectfully request that we do that in a future hearing. So, Mr. Turpin, in your testimony, you state that FERC has undertaken significant efforts to implement its responsibilities under the FAST Act. Can you elaborate a bit on your efforts? Sure.
When the FAST Act, I think within 6 months of its passage, all the subject agencies had to post existing projects. For FERC, I think we had the most significant number of projects that went up on the dashboard. And most of the efforts were at that point, those projects had been through the FERC pre-filing process, had already had a lot of the coordination. FERC was the lead agency for those. So a lot of that effort was at going back to document the things we'd already done and put up coordinated project plans, not as a sort of a prospective plan, but as a historical, acknowledgement of the things that the agency's already been through. We found that it did take a lot of time to coordinate the various agencies' data. Some agencies would be unwilling to commit to schedules, and it does take quite a bit to kind of ride herd on the data that has to get posted. So that's the bulk of the work we did in trying to set up.
So do you think it will help now when you have this interagency coordination, when everyone's sitting at the table and you can, maybe some agencies can look at others and say, why aren't you adhering to this schedule and timeline?
And that's essentially what I think we've tried to do through the pre-filing process as well. I mean, as the lead agency, we try to bring those folks to the table and try to get them the information they need so that they can advise us of the schedule they need.
And you also state that some of the provisions in the discussion draft would duplicate efforts. How so?
That's predominantly the tracking of everyone's project schedules. I mean, that is what happens on the FIPSI dashboard, and then it would be a duplicate effort at the commission.
Mm-hmm. Well, it's clear we need to hear more from FIPSI to understand what it has achieved in the year plus that it has been in operation already, and I fear that we're simply setting up a duplicative process with this proposal, so I have serious concerns with the discussion draft today. I think we need to have FIPSI here, and remember, this is only a year and a half old, and it was the Congress's intention to promote greater efficiency by bringing that interagency group together. I yield back my time.
The gentle lady yields back. The chair calls upon the gentleman from Virginia, Mr. Griffith, for 5 minutes.
Thank you. Thank you very much, Mr. Chairman. I do appreciate the witnesses being here. Mr. Katz, I was pleased to read in your testimony and then to hear in one of the earlier questions that you all are fine with H.R. 446 related to Gathrite Dam and H.R. 447 related to the Flanagan Dam, and I appreciate that very much. Thank you. I am also interested in, not only electric generation, but making sure that we have jobs in my district. One of the great concerns in the coal fields has been is that production has been down, and folks have said you all need to reinvent yourselves. We think coal has a long future, but at the same time, we want to make sure that we're looking for new ways. A couple of my friends in the Virginia General Assembly got a bill passed this last year. I had mentioned it in a previous hearing that there were some folks interested in doing some things related to pump storage projects. And what they're trying to encourage with the Virginia language is to see if they can entice somebody into putting a pump storage facility inside an exhausted or abandoned coal mine. making it a closed-loop system. I appreciate your written testimony on those issues as well. One of the questions that you raised, and I'd like for you just to do some explaining for me, is you felt like there was, because of the add-ons, and I'm probably using the wrong language, but the additional energy items that, like solar or wind, to help pump the water up, that there was a problem in the draft language that we have floating around, at least that's the way I interpreted it, with municipals, maybe adding on non-municipals. Could you explain that to me?
Sure. It's kind of a historical artifact, but years ago, back in the 80s, there were instances before the commission. Well, I should draw back.
Way back in the 80s.
Yeah, when I was a youngster. I guess I should drop back 5 yards. I mean, the Federal Power Act, in the Federal Power Act, Congress provided that a municipality would get a preference over a private entity in obtaining a preliminary permit or a license. So if they, all things being equal, if a city applies and a private company applies, the city wins. And at some point in the 80s, the commission discovered that municipalities were applying and saying, I'm a muni, give me preference, but then as soon as they got the license or permit, or even during the process, they would turn around and sell it to another private entity, not the one that was trying to compete with them, but somebody else. And so the commission decided that was not fair competition, and it was not appropriate to put private entities at a disadvantage. So the concern that I expressed with regard to that portion of the bill was it would appear to allow a municipality to outcompete a private entity in the first instance, and then do what the commission has hitherto precluded agencies from doing, turn around and sell it to a different private entity, so that the private entity that was trying to develop the project, and indeed it might have been the entity that was out there in the field first, would be placed at a disadvantage. That's something for Congress to consider.
Okay, and I appreciate that. And so it's not really a concern over just closed loop pump storage, but a concern that and then perhaps the solar or the wind might be transferred as you just described. Is that correct?
Yes, it's not specific to closed loop. It's just that's, I believe, the only one of the bills in which that language appears. So that's why I raised it in that context. But no, it is not something that is in the nature of closed loop pump storage.
And otherwise, in regard to the draft language on closed loop hydro pump storage, you all feel fairly comfortable that we're headed in the right direction on that?
I think it has a lot to commend it. Again, we'd be happy to work with committee staff just to make sure that there are no duplicative areas or things put into the statute that make things take longer or are repetitive of other agency actions.
Because as some of the other witnesses on both sides of the aisle have pointed out, that when you're using hydro, that's a very clean source of energy. In the case of using a captive water source inside of an abandoned mine, you really don't have a whole lot of problems as long as initially it's structurally sound, of course. But we believe that we have a number of those sites in Southwest Virginia, maybe some in my friend Mr. McKinley's district over in West Virginia as well. But we believe that this is one way that we can continue our region's long-standing history working in energy, and at the same time create jobs in a field in an area where jobs have disappeared as a result of some downturns in the economy and some regulations that we're going to try to work on.
Yes, if I may, I'll say
yes, please.
The commission approved a project of that type in California, the Eagle Crest Pump Storage Project, which is using an abandoned mine and is currently under development. So those kinds of things can indeed make sense.
All right, I appreciate it very much, and I see my time is gone. I yield back.
The gentleman yields back. The chair calls upon the gentleman from New York, Mr. Tonko, for 5 minutes.
Thank you, Mr. Chair. Mr. Turpin, welcome. I have a few questions concerning the interagency coordination discussion draft. Do you believe that aerial or remote surveys have limitations?
At this time, I do. I think the commission and its staff has had a long history of accepting remote data in terms of looking at the initial environmental impacts, but then they need to be truthed up, after an authorization before construction can start. There just simply are limitations. You can't always count on that to get species counts. There are certain kinds of wetlands that aren't able to be delineated aerially.
Thank you. And can aerial survey data be unreliable regarding the presence of endangered species, historic properties, such as archaeological sites and characterization of wetlands?
Yes.
Okay, does the draft before us include any standards or methodology requirements that must be met in order for an agency to be required to consider data from remote surveys?
No, I did not see anything about minimum standards.
Okay, thank you. And so there would be no quality control requirements that might consider the degree of accuracy, of scale, of elevation, of vegetation strata and density, soil profiles, or many other factors that could vary widely depending on the geographic region and methodology employed in that survey.
Yeah, again, I saw nothing of that in the bill, and took that to mean that that would be left up to the individual agencies.
Mm-hmm. Does this discussion draft require applicants to attempt to conduct ground surveying before using remote surveying?
Not that I read, sir.
And in which case, applicants would not be required to make a good faith attempt to gain access to perhaps private property owners' land, and in so doing help to make an important stakeholder aware that this project is being developed, potentially through their property. There may be streamlining we can consider in the application process, but I really do believe that any attempts to skirt the rights of landowners, especially when the outcome is less than perfect data, would be a step in the wrong direction. Is that a concern that I should have?
I think, well, the Commission's stance in the past has been that the best course of action is to get the best available data for the NEPA analysis. And the Commission's encouraged pipeline companies to go out and actually seek, pipeline right-of-way access to develop that data. But if it can't be achieved, then Commission staff has relied on remote and aerial data.
I hear. I would also recommend that the committee receive more feedback on this provision from other federal and state agencies to understand how inadequate data might affect their review process and the associated regulatory requirements. Mr. Turpin, in your testimony, you state the Commission's current review processes are thorough, efficient, and have resulted in the timely approval of the facilities necessary for natural gas pipelines. Generally speaking, how long does it typically take for a pipeline permitting process or permitting application to go through FERC's process?
It can vary pretty widely, so there's not a really great typical time. As I mentioned earlier, for the full spectrum of projects filed at the Commission for pipelines, 88% of them are issued within 1 year, and that does go from very small projects. Usually, once you begin to increase the length of the line and the complexity of the project, the time does tend to stretch out because there are simply more stakeholders engaged, more issues to consider, and more agencies to have at the table.
But in general, within a year?
88% within a year, yes, sir.
Which seems to be, given the importance of the review, seems to be a fairly expedited process. Done thoroughly. So with that, Mr. Chair, I'll yield back.
The gentleman yields back. The chair calls upon the gentleman from Ohio, Mr. Johnson, for 5 minutes.
Thank you, Mr. Chairman, and gentlemen, thank you for joining our panel this morning. Mr. Katz, this committee received testimony sometime back from a developer that had difficulty with a project on an existing non-powered dam under the Army Corps of Engineers jurisdiction. Apparently, they had to perform 2 separate NEPA analyses, one for the FERC license and a separate analysis triggered by the Clean Water Act for the Army Corps. I understand that you have an MOU with the Army Corps, but what could FERC do to prevent this type of duplicative application of NEPA in the future?
Well, sorry to give this answer, but ultimately there's not anything we can do. We don't control the Corps, but as you noted, we have—
Your MOU doesn't address that? That kind of collaboration?
Yes, the MOU does. The MOU seeks to have the Corps and the Commission act concurrently to the extent possible, and that's as far as we've gone. But as a legal matter, we have no authority over the Corps, so if the Corps decides it needs to do more environmental work, we can't prevent that. We also have a number of instances in which we have issued licenses for projects at Corps dams, and the Corps decides it needs to take a certain amount of time, whether it's to review the physical characteristics of the dam or to issue permits such as the ones that you refer to, and the commission does not have any authority to do anything about that.
Do you have a personal opinion as to the waste and the duplication of having both the Army Corps and FERC require NEPA studies on the same project?
My opinion is that agencies do need the studies they need in order to carry out their statutory mandates, but I don't think there should be duplicative studies, and ideally they would be done concurrently so that there's as little use of time as possible.
Yeah, you would think that if you did one, you could use the same application for both agencies and do it one time. I mean, I'm a plowboy, so common sense kind of reigns.
Yeah, that would be hoped, and often the Corps is a cooperating agency with the FERC when FERC does its NEPA document, and then the Commission can do its best to make sure that everything is in the NEPA document that the Corps might need.
Okay. All right. I understand that one important project parameter left unresolved until very late in the permitting process is the water quality standard, which, as you know, determines the amount of water that will ultimately be available to pass through the turbines in a dam, a power dam. Currently, the Corps may prescribe different water quality standards from the FERC and the state standards, beginning in some cases in the 6th or 7th year of the federal permitting process. This can cause significant problems from both a commercial and a planning perspective. Would you care to comment on this issue? Is that part and parcel of the same kind of deal we're dealing with the NEPA analyses?
It may be to some extent. I think that those issues only arise where a project is located at a core dam. The Corps can't prescribe water quality standards if it's at a non-core dam. But yeah, if a project is at a core dam, the Corps essentially has the ability to require the licensee to do whatever it is that the Corps sees fit to do.
Having the ability is one thing, but this is another example of duplication. And in my opinion, it appears to be government waste and wasting the time of the businesses and those that are trying to get these projects done. Would you agree?
It can be. Our experience is that different core districts behave different ways. Some core districts are very welcoming to hydro and try and do everything they can to promote hydro being built at core dams. Other districts don't seem to favor hydro at their dams.
I appreciate that comment. Different core districts behave in different ways. Wouldn't it be great if they all were kind of talking to one another and doing things the same way?
Yes, I think it would. I mean, one of the things FERC is lucky about is that we're a small agency, so if the chairman wants to know what I'm up to, she can walk down the hall and look me in the eye, as opposed to I'm located out in some far region of the country, and I think it's harder for folks in Corps headquarters to control all their aspects.
Okay. Lastly, for how many licenses issued or pending before the Commission has the FERC and the Army Corps MOU been employed to unify the NEPA review process? And how many of those instances has the Corps used a FERC-generated NEPA review when approving a project? So has there been any crossover that you can recall where one agency used a NEPA from the other?
There certainly have been in the past prior to the MOU. The MOU is fairly recent, so I'm not certain whether it has come into play in any cases where we've actually issued licenses.
Can you provide us with the language around the NEPA analyses that's in the MOU? I'd like to see that. I'd like to see how much discussion actually went into it. Mr. Chairman, I yield back.
Yes, I'd be happy to do that, and we also can let you know if there are any instances in which the MOU has been applied.
Okay. Thank you very much.
Thank you. The gentleman's time has expired. I now recognize the gentleman from Oregon, Mr. Schrader.
Thank you very much, Mr. Chairman. Appreciate that. I guess Mr. Turpin, Mr. Katz, and others have talked about the concurrent review process. Do you see any problems, particularly with accelerating a more concurrent review process by all the different agencies?
No, concurrent reviews are what's desired. I think the rub becomes if the information needed by those other agencies can be developed at the same time as we're doing our review.
That would hopefully be established, whatever process would be set up to begin with. The states would be an outlier, though, as I understand. They are not subject to any federal regulatory authority in terms of when they get their act together and decide to approve something.
The states that are acting under their own authority would be preempted by the federal permits, but the state agencies acting on federally delegated authority for federal permits carried the same weight as the feds.
So that's something we'll have to figure out going forward, looks like. Mr. Katz, do you agree that the bill dealing with cross-border approvals, the new cross-border approval process that's being suggested, confines the permit process to just a segment on the border and doesn't allow any discussion of the entire project?
I am not certain that it does that. The commission would have to do whatever NEPA review is appropriate, and I don't think that the bill precludes the commission from looking at other impacts.
Okay, that would be my read of the bill, actually, also. While the bill says there's no cross-border review for modifications of an existing cross-border facility with regard to cross-border authority, are there other agencies or regulatory authorities and permitting processes that someone trying to modify a facility would need to abide by?
I am not aware of any. I defer to Mr. Herman. DOE, if there's a change in the commodity level, DOE might have to approve it. But again, I defer to Mr. Turpin for further discussion.
It's going to depend on what equipment's needed for that modification. If it's a compressor station for the case of a natural gas pipeline, they'll have to comply with the Clean Air Act. I don't know enough about pump stations for liquid lines because we don't currently deal with those.
What about an expansion of the footprint of the facility?
That, again, it would depend on what exactly the equipment's being installed as to if there'd be federal oversight or not.
Okay, but not any additional land being taken into the facility would not be an issue then? It's just the type of equipment that would be there?
It's usually installation of additional features and increasing the footprint that drive most of the environmental issues.
Okay. Then there's a 30-day approval deadline for export-import natural gas cross-border. You see that hampering public input or the ability to get the permitting process done, the approval process?
As I read the bill, the 30 days was applicable to the DOE commodity determination, and so I don't think that would affect the FERC process.
All right, very good. Mr. Katz, in the legislation about promoting hydro development at existing non-powered dams, I'm not that familiar with some of the current regulatory framework. It's being proposed to switch to that which is necessary to protect public safety or reasonable economic feasibility and prevent damage to fish and wildlife. How is that language different than what the current regulatory authority is?
The language is different to the extent that it could be read to preclude the commission's considering some other resources that it now considers, like flood control, irrigation, recreation, historic preservation. The standard is also different. The standard, as I read the bill, was that measures had to be economic and essential for fish and wildlife, and that's a higher bar than currently exists.
Okay, very, very good. And with that, I'll yield back, Mr. Chairman. Thank you.
I thank the gentleman, and I recognize the gentleman from Texas, Mr. Barton.
Thank you. We have out in the audience, Mr. Chairman, Andy Black. Andy Black's a former personal staffer of mine and former staffer of the committee and also former senior official over at FERC, and he just lost his dad, and I think just got back from the funeral yesterday. So on behalf of the committee and me personally, we're with you in your time of sorrow. I never met your father, but I heard nothing but great things about him. So, and we look forward to your testimony on the next panel. Mr. Chairman, I just have a couple of questions. Under current law, we handled permitting for oil pipelines domestically and gas pipelines differently. Is there any real reason to do that? Other than that's the way we've always done it?
I'm not sure if that was addressed to me, but no, not particularly. I mean, the same thing is true with electric power lines. Congress sets up whatever scheme of regulation it sees fit to do.
So it's just kind of the way it happened, but if we're going to do a pipeline reform bill, is there any reason we couldn't use the same regulatory authority and permitting process for oil and gas pipelines?
No, Congress has the authority to do that if it wishes.
Good. In the Energy Policy Act back in 2005, we tried to give your agency, the FERC, the authority to oversee the various other agencies that had to do all the various pipelines that Mr. McKinley was talking about earlier. That doesn't seem to have worked too well. The delays have gone up, not down. What went wrong, and what do we do to fix it? Do we need more incentives, or do we need more penalties, or do we just need better people at the FERC? What's going on?
Well,
you don't think the latter?
I would never want to say that our commissioners, the staff is less than perfect, but the commissioners are perfect. I don't know that there's anything that Congress did wrong in the bill. I think that what's happened since, and I'll defer to Mr. Turpin if he wants to speak to it, is that there has been an increasing emphasis on public interest in the pipelines and opposition to pipelines, concerns about environmental effects, the type of production methods that are used, so that back in the day, pipeline regulation and approval was a fairly sleepy part of the Commission's business. Now it's something that a lot of people are interested in and very vocal about, and I think that's more what is taking more time than anything that Congress is responsible for having done.
Turpin?
I'd agree. I'd also say staff's pretty good too. But I think that's a large part of it, is the increased public interest. I mean, from a very wide audience in the U.S. And as with the current approach, fundamentally the Commission can engage these agencies, and Commission staff can do the work, but all these agencies have to comply with their own congressionally directed mandates, and it's that sort of knot that I think we all end up tripping over.
Well, I'm not the chairman of the committee. I'm the vice chairman. But I think we're going to do a pipeline permitting reform bill, and we'd really like your agency's input. I think it's good to have more public input. I don't think that's a bad thing. I think that's a good thing. But having said that, you still need, once you get that input, you need to make a decision. You need to live within the guidelines. You need to live within the deadlines. If our deadlines are too strict, maybe we need to expand them a little bit. But we're going to need a lot more energy infrastructure in the next 20 to 30 years. And pipelines are going to be a big part of that. And so if we didn't quite get it right 10 or 15 years ago in the Energy Policy Act of 2005, let's get it right this time in the Energy Infrastructure Review Act of 2017 or 2018. With that, Mr. Chairman, I yield back.
I thank the gentleman, and I recognize the gentleman from Indiana, Mr. Bouchon.
Thank you, Mr. Chairman. Mr. Katz, in my district and nearby, there are multiple dams that currently don't produce hydropower, but potentially could, as you're aware. In 2013, Congress directed FERC to investigate the feasibility of a 2-year licensing process, develop criteria for non-powered dams and closed-loop pump storage. I guess you had a pretty good experience at the Kentucky Lock and Dam project. What elements of a 2-year pilot program should Congress make permanent based on FERC's experience with the 2-year pilot?
I don't want to get ahead of the Commission staff because we are right now compiling a report that Congress directed us to do in the 2013 statute.
Okay, so we got to wait for the report.
But yes, as I said earlier, though, even in the absence of any kind of regulatory statutory changes, some 25% of the original licenses that the Commission worked on in the last 13 years or so have been permitted in 2 years or less, so it can happen.
Understood. And would these for these two type of projects, would these type of projects raise the same environmental and wildlife issues as traditional hydro?
The same issues get considered, but they're generally considerably less in scope because the existing dam has already had a certain impact.
So it might have an impact on the timeline than if it was easier because of that.
Such projects tend to be easier, not as an absolute rule, but they tend to, yes.
Would the draft legislation relating to non-powered dams and pump storage in any way alter the FERC's environmental analysis under NEPA?
I believe I answered an earlier question.
Probably did.
It looks as though it would, in that it only calls out fish and wildlife resources and doesn't call out flood control, irrigation,
Okay, that's what
water supply, and other things. And also, it seems to set a higher standard for the conditions that would be imposed, a higher bar.
How about the Clean Water Act or the Clean Air Act? Any differences there?
Nothing.
On these type of projects?
Clean Air Act issues are almost never implicated in hydro projects. Clean Water Act, the
draft legislation have any impact on that?
I don't know. I don't think it would, but it's conceivable. We'd have to study that.
Okay. I yield back, Mr. Chairman.
I thank the gentleman, and I recognize the gentleman from Texas, Mr. Flores.
Thank you, Mr. Chairman. Mr. Chairman, thank you for holding today's hearing. America's shale energy revolution has dramatically improved our energy security here at home. The U.S. is now one of the top producers of oil and gas in the world, yet there are still existing infrastructure challenges to deliver those resources to consumers. Modernizing our infrastructure to efficiently and safely bring energy resources to consumers helps create jobs and brings lower energy prices for hardworking American families. So with that, I'd like to get into my questions. Some of these were partially asked by Mr. Rush, Mr. Green, and Ms. Castor. Mr. Turpin, I understand that the Commission does what it can to encourage the participation of other permitting agencies today to identify issues and work to resolve them. Unfortunately, at times, the other federal agencies have chosen to not take their responsibility seriously. They may simply choose to just not act on a permit. In your experience, why do some agencies choose to go that route, to not work with you?
I think it's, excuse me, from a global perspective of agencies working with us, it's fairly rare for someone to refuse to participate in the FERC pre-filing process or in coordination with staff. Whether they choose to be a cooperating agency under NEPA is a different question. They have their own interests to protect in terms of if they want to be an intervener in the FERC process later. I think in large part the rubs come down to them having a different criteria for the data they need to do their permit, as well as their own resource constraints. We're a sole purpose agency. We look at this infrastructure. Other agencies have multiple mandates, and they've got to balance their needs as best they can.
When you look at the legislation that places the mandate on the agencies to carry out their obligation concurrently in accordance with the schedule established by the Commission, do you think that legislation goes far enough, or should we try to go farther to compel coordination and timely coordination?
I think that's a difficult question. Trying to compel the timely coordination requires, the language always has in it the caveat of unless otherwise mandated in other laws or unless an agency can't meet its other obligations. And that's been in all the versions I've seen. And so that's sort of the Gordian knot. And having the Commission in charge of all of those mandates for these other agencies seems a bit inefficient from our perspective.
Are you aware of a strategy used by pipeline opponents like the Sierra Club and others to block access to land for route surveys?
I have heard of landowners blocking access, not granting survey access to pipeline companies, but not NGOs or any kind of other organization.
Okay. To the extent they do that, I mean, it's pretty obvious, but can you tell the committee what impact that has on you doing your job?
As I said earlier, the Commission staff prefers to have the best information, from the ground data in the ground surveys in the application, but without it, we can move to desktop data, we can move to remote data, and we can move forward with our analysis. That does have to be truthed up later before construction, and so sometimes there are potential implications that certain protected features won't be discovered until after the authorization, and then the applicant has to do an expensive reroute or some lengthy adjustment.
Okay. The permitting dashboard in the draft legislation would consolidate the information from your agency as well as the other coordinating agencies into a simple, easy to use and easy to access website. You admitted it would improve transparency, but you also say in your testimony that it would burden staff resources and time. How do we balance the need for transparency with scarce government resources?
Good question. I'm still trying to figure that one out in my role here. I think that's always the rub. We don't have a lot of excess staff sitting around with a lot of excess capacity. We're all technical specialists, and we try to use everybody to their full capacity. So adding on sort of riding herd on these other agencies just does dilute that effort. So, I mean, we can do it.
And with respect to this this permitting dashboard, again, staying out of the weeds, if the FERC didn't collect this information, who would or should or could? I mean, you're the lead agency for permitting pipelines. Aren't you the logical owner for this project?
Yeah, we are. And as the current process we have, it is the applicant that is going out and filing for these permits and engaging those agencies that's responsible for collecting that data and reporting it into the record.
Okay. Mr. Chairman, thank you. I yield back.
Thank the gentleman. And I recognize the gentleman from North Dakota, Mr. Kramer.
Thank you, Mr. Chairman. Thanks to the witnesses. I want to hone in a little bit on some statements that were made earlier and see if we can't find some common ground, because I appreciate what Mr. McNerney said earlier about we'll never solve this if one side imposes its will on the other. I agree. I think Ms. Castor makes a relevant point, admonishing us to see how the FIMSI process works. We do have some pretty successful pilots, and I think they could be even more successful if the interagency collaboration was more, I guess, more cooperated by more agencies on federal lands, where we've seen some permitting activity actually create efficiencies by actually co-locating some agencies, even in field offices. What I'm wondering about on the interagency issue here is, can we find ways or even substantiate that interagency collaboration and cooperation can accomplish two goals? One, to streamline the permitting process so that those of us who want to see the process shortened can be satisfied, as well as find synergies, not just efficiencies, but synergies among the agencies where there's even greater environmental oversight and scrutiny in that shorter time frame, so that there doesn't have to be a loser, but rather two winning sides. Is that too much to hope for, or can that be substantiated? And I'd ask either or both of you for your experiences.
No, I would say that what you say makes a lot of sense and indeed is a viable and very positive goal.
Do we have any experiences where that could be demonstrated, or?
The commission participated kind of ex officio, because it wasn't any of our projects, in the interagency task force that you talked about, which I think primarily related to getting transmission lines on federal lands permitted. And our impression, watching it a little bit from afar, was that the agencies did a very good job of working together and doing things concurrently and trying to solve everybody's problems at once. And in some projects that come before the commission, that happens and things go very well. Other times it doesn't. I guess the question of getting it to be consistent and to be the rule rather than exception is perhaps the difficult thing.
And perhaps that's more a matter of the will than it is policy. However, Mr. Turpin, I don't know if you have anything to add to that, but is there a way to incent that within the agencies? In other words, I think the natural tendency is to slow walk things. If you're just the bureaucracy doing your things sequentially, right, and you have 90 days, generally it takes 90 days. If you hadn't noticed, Congress usually extends their deadlines so that we can take longer. So what I'm wondering is there a way to properly incent that behavior that we seek in an actual streamlining process without violating the integrity of oversight and scrutiny?
I think it comes back to sort of setting the priorities for the agencies. I mean, they're given multiple mandates. Again, we're a single focus agency, so it's easy for us to stay on the track. Other folks who have very widely different missions to carry out have to do that balancing act, and so having that priority set for them would go a long way.
I do wonder sometimes if we couldn't harmonize some of that, again, while maintaining the integrity, but that's beyond, obviously, your agency's responsibility and scope. Since I have time, with regard to the presidential permits and crossing border on the oil side, which is the difference maker, right, from natural gas on international pipelines, this national interest determination, which is what the president ultimately has to make where a presidential permit is determined. If I understood, I think your answer to a previous question, you, while consulting the National Security and Homeland Security and other agencies, State Department, you are in essence not neglecting the national interest, especially on the security side, in your process with gas pipelines. Would that be accurate? And I don't know whether the determination of the standard for the permit is the same, but it seems that the considerations are the same. Is that fair?
I mean, with the natural gas process, you know, under NGA Section 3, we do the environmental review, we look at the facilities installation, and under the executive orders for the presidential process, we reach out to state and defense to get their concurrence on impacts to areas that they oversee.
Thank you for your work and for your testimony. I yield back.
I thank the gentleman. I recognize myself now for 5 minutes of questioning. Mr. Katz and Mr. Turpin, thank you for being here. Mr. Katz, the discussion draft would designate hydropower as renewable energy under the Energy Policy Act of 2005. How has hydropower development been adversely affected by the fact that it's not always considered renewable?
That's one, again, that I would more have to defer to the second panel who deal with it on a day-to-day basis, but certainly there are government programs, tax credits, other things that have not been available to the hydro industry when it is not considered to be a renewable resource.
Seems to make sense, so I guess we'll wait for that second panel. Let me ask you, as you know, the small conduit hydropower plays an important role in our nation's energy mix. It's a great option to add renewable generation to existing infrastructure. It's installed almost anywhere, even in remote places. The Hydropower Regulatory Efficiency Act of 2013 created a streamlined process for qualifying conduit facilities. What's been your experience since then?
Our experience has been that that process has gone very smoothly. We've almost never had any comments when someone proposed to have a qualifying project, so it's gone very quickly. In terms of the new legislation, which would cut the comment period back to 15 days, Commission staff supports that. Indeed, we're not certain why it might be limited to projects of 2 megawatts as opposed to the 5 megawatt projects that are already covered by the Act. And indeed, I'll go further to say the Commission staff has previously testified to Congress that it very well would be appropriate to exempt all conduit projects from Commission regulation, given that the conduits themselves are subject to whatever appropriate environmental regulation goes on when a conduit is built, and that they very rarely, if ever, have additional environmental impacts.
So you would be supportive of Congress shortening the time period at the very least?
We see no downside to that.
Okay. Let me ask this question, and both could respond. How does the current FERC process hinder hydropower projects' upgrades, such as those that would increase the efficiency, capacity, and output of existing plants?
I think it can vary from project to project. Again, if you have a fairly simple project that the stakeholders are comfortable with and doesn't have significant environmental impacts, it can go forward very quickly. If it's a major project that brings into play the Endangered Species Act, the Clean Water Act, and other regulations, that can significantly delay consideration of that amendment.
Okay. Thank you. I yield back my time and now recognize the gentleman from Oklahoma, Mr. Mullins.
Thank you, Mr. Chairman. And first of all, I want to thank my colleague across the aisle, Gene Green, for working with me on this issue and working together with us on so many different issues. We've worked together in the past, and I look forward to doing it again. Mr. Turpin, as you know, the process for reviewing cross-border infrastructure is established through a series of executive orders, and I think you know where I'm going with my questioning here. In fact, Congress has never weighed in, and there are no current laws on the books. The draft legislation before us today would be the first to establish a uniform and transparent process in authorizing cross-border energy infrastructure. Would the draft legislation change the Commission's existing process for reviewing cross-border gas pipelines?
I do not believe it would.
Would you have any concerns with that? When I say you don't believe it would, I just want to clarify it.
Let me add to that. I don't believe it would change the review of the facilities. The environmental review that we do, the current reviews that we do under the Natural Gas Act, under the bill. Of course, we would not be reaching out and coordinating with state and defense any longer.
Should it basically be you'd follow the same process, kind of like what Mr. Kramer was saying?
Right.
Does the Commission have the technical capacity to take on the new responsibility?
In terms of adding oil pipelines, I mean, pipelines to a large extent are pipelines. There'll be some uniqueness to the product in it that we haven't had to deal with before, but we can get that expertise.
Uniqueness by?
Natural gas. I mean, as an oil, as a siting matter, transport of oil is something we've not had to look at. So there'll be considerations for spills, considerations for that sort of thing.
Would FERC treat oil pipelines like gas pipelines with respect to identification for the jurisdiction purposes?
I don't know. That would have to be set. The policy for that would have to be set by the Commission, which is, I think, what would be done in that year-long rulemaking. And then Commission staff would act on whatever policy the Commission comes up with.
Do you have a problem with the time frame to which we put forth with approving the permit?
As I read it, it's 120 days after the final NEPA document, and that's not an issue.
Not an issue. Would the draft legislation have any effect on the NEPA or shortcut the Commission's environmental review in any way?
I do not believe so.
Okay, that real quick, that was all I had. I just wanted to clarify some concerns that we've heard about this. So, Mr. Turpin, appreciate it, and Mr. Chairman, I yield back.
Thank the gentleman, and I recognize the gentleman from Missouri. Welcome back, Mr. Long.
Thank you, Mr. Chairman. And Mr. Turpin, the Promoting Interagency Coordination for Review of Natural Gas Pipelines discussion draft requires early outreach to permitting agencies. How does this help FERC and other agencies coordinate to make sure their input and concerns are addressed?
I think it allows the applicant to get out to those agencies at the earliest possible time before they've developed the route, before they develop the project, so that the agencies can identify what data needs they have, can influence what the applicant does in the design to mitigate any impacts, and give the applicant the most notice on what sort of studies might be needed for when the applications are filed.
Okay, can you discuss the ways that we could reduce the uncertainty in review schedule to make sure the reviews are completed in a timely manner?
I think the largest, single most crucial factor in doing that is developing the data needed by all the different agencies for their mandates.
Okay. Mr. Katz, you mentioned in the next 15 years, almost half of licensed projects will begin the relicensing process. How can we make sure that the relicensing projects are completed in a timely manner?
It's a difficult ask, given that there are statutory mandates that allow other agencies to, in effect, set the time frame. I think that some of the efficiencies that are being proposed in the current acts will help.
Say that again. You think that what?
I think that some of the measures provided in the acts before us will introduce efficiency and help the Commission move ahead to do things in as timely manner as possible. I mean, I think the Commission staff and the Commission itself will be committed to getting those licenses done as quickly as possible, but we don't have complete control given the exercise of authority under federal law by state and other federal agencies.
All right. Currently, FERC can grant an extension of just 2 years from the commencement of the project construction. Could you expand on how the discussion draft gives FERC flexibility on cases that require additional time to begin construction?
Yes, the discussion draft would allow the Commission to extend the commencement of construction deadline for several additional years, and that might help certain projects that are having trouble sort of dotting their I's and crossing their T's before they get started. So it would be a help to some projects.
Okay. Mr. Chairman, that's all I have, and I yield back.
The gentleman yields back. Seeing there are no further members wishing to ask questions for the first panel, I'd like to thank both you, Mr. Turpin, and you, Mr. Katz, for being our witnesses today. This will conclude our first panel and will now take a few minutes to set up for the second panel. Welcome back. And thank you for your patience and for taking your time to be here today. We now move into our second panel for today's hearing. We'll follow the same format as the first panel. Each witness will be given 5 minutes for an opening statement, followed by a round of questions from our members. For the second panel, we have the following witnesses. Mr. Jeffrey South. He's Legislative Director and Political Director at the International Union of Operating Engineers. Mr. Jeffrey Leahy, the Deputy Executive Director of the National Hydropower Association. Mr. William Robert Irvin, President and CEO of American Rivers. Ms. Jennifer Dennis, the Senior Staff Attorney at the Eastern Environmental Law Center. Mr. Donald Santa, President and CEO of the Interstate Natural Gas Association of America. And Mr. Andrew Black, President and CEO of Association of Oil Pipelines. We appreciate y'all being here today. We begin this panel with Mr. South, and you're now recognized for 5 minutes to give an opening statement.
Thank you, Vice Chairman Olson, Ranking Member Rush, members of the subcommittee. It's an honor to join you at your first legislative hearings of the 115th Congress. My name is Jeffrey South. I'm Legislative and Political Director of the International Union of Operating Engineers. The union represents almost 400,000 men and women in the United States and Canada. In short, we build and maintain the cranes, bulldozers, and backhoes that build North America. Members of the operating engineers are some of the most highly skilled, highly trained construction craft workers in the world. We deliver training at over 86 facilities in the United States where we employ 550 instructors. The IUOE and its employers invest over $128 million annually in local apprenticeship and training programs. And I want to point out here, at no cost to the public. That's exclusively privately financed. In addition to the training of local unions, the IUOE conducts specialized national training in coordination with the Pipeline Contractors Association in the pipeline sector. We invest over $5 million annually in that work to ensure the safe installation and construction techniques in the pipeline industry, making it the safest in the world.
pipeline training program has historically been delivered at locations around the country where there's a large project or a regional demand for pipeline training. But I'm pleased to share with the committee that the IUOE is building a new home for its pipeline training in Crosby, Texas. In spring 2018, the IUOE will open our International Training and Education Center, a $150 million training center in the heart of the Gulf Coast. I've attached a rendering of the facility and a site plan of the project where you can see just how much of that property is dedicated to pipeline training. And again, this facility is being built at no cost to the public. There are no public resources, no taxpayer dollars whatsoever associated with that $150 million investment. Let me turn now to employment and wages in the construction sector and in the pipeline industry in particular. The construction industry has the highest unemployment rate of any industry sector at 8.4%. Employment in the oil and gas pipeline sector of the construction industry is near a 5-year low. Please see the chart attached to my testimony. As you can tell from it, we're down nearly about 20% of total jobs in the sector since the summer of 2015. I should point out that these are good, family-sustaining jobs. Production and non-supervisory workers make over $30 an hour in the pipeline industry, and compare that to $21.90 in all private sector payrolls. After that description and background of the IUOE's role in training and our look at labor market information, let me turn to the legislation before the committee and two pieces of legislation in particular related to pipelines. Regulatory uncertainty and procedural delays during environmental review are hindering the growth of these good jobs and the other benefits that go along with this domestic energy production. Congress needs to update and streamline the permitting and regulatory framework to ensure that domestic oil and gas industry flourishes in a safe and predictable way. To put it simply, it's time to modernize the federal code for energy infrastructure. That's why the IUOE supports the Cross-Border Energy Infrastructure Act and the Promoting Interagency Coordination for Review of Natural Gas Pipelines Act. The cross-border legislation in particular takes the important step of codifying the process to permit a project that crosses the border. Now that there is not a controversial project under consideration, it's the right time to make this move away from the ambiguity of an executive order. Frankly, it's time to legislate regarding cross-border permits. The State Department's Inspector General described the problem in its special report in February of 2012 when it reviewed the Keystone XL permit process. It determined that the limited expertise and experience of State Department officials with respect to NEPA and environmental reviews frustrated and delayed the permitting process for KXL, perhaps even leading to a need for a whole supplemental EIS and adding 11 months to that process. It's time to place responsibility for cross-border permits in an experienced environmental agency like FERC. The Interagency Coordination Bill makes important reforms to natural gas pipeline permitting. The bill will give FERC additional tools to identify potential issues that can hinder state and federal agencies from conducting timely reviews. It's an important evolution from the simple 12-month limit legislation that has been considered in past Congresses, and it's time to more closely address it. This legislation more closely addresses the real problems associated with permitting delays. The IUOE encourages you to pass these two pieces of legislation, and we look forward to working with the committee to enact them in this 115th Congress. And thank you, Vice Chairman Olson, for the opportunity. It was a pleasure to join you today.
Thank you, Mr. South. The chair now calls upon Mr. Leahy for 5 minutes for an opening statement.
Vice Chairman Olson, Ranking Member Rush, and members of the subcommittee, thank you. I am pleased to be here to discuss the importance of hydro to the electric system, its untapped growth potential, the challenges that impede growth, and the bills before the subcommittee today. Hydro provides 6 to 7% of all electricity generation and nearly half of all renewable generation, making hydro the largest provider of renewable electricity. Another 42 pump storage plants make up almost all, 97% of energy storage. This system contributes to cleaner air and provides other benefits, including river management for fish and habitat protection, flood control, drought management, water supply, irrigation, and more. Hydro also provides many grid benefits: baseload power, peaking generation, load following, reliability. With the growing need for these services, hydro has increased capacity by nearly 2 gigawatts since 2005. Hydro infrastructure also brings many economic benefits. The industry employs a workforce of almost 150,000, and access to low-cost, clean, reliable power attracts many high-tech firms and manufacturers. But hydro can do even more. The myth is that hydro is tapped out, but that is not the case, and I direct the subcommittee to the 2016 Department of Energy Hydropower Vision Report. This report, with input from industry, environmental groups, and state and federal agencies, outlines 50 gigawatts of growth potential by 2050. Let me highlight 2 prime examples: pump storage and building on existing infrastructure, non-powered dams and conduits. The focus of 3 of the bills today. Pump storage can rapidly shift, store, and reuse energy until there is corresponding system demand, while facilitating the integration of variable generation. As more intermittent renewable generation is added to the grid and other baseload generation is lost, the need for pump storage is increasing, particularly in the West. Of the 80,000 U.S. dams, only 3% generate electricity, highlighting the potential in the non-powered dam sector. Many of these opportunities are located in regions some may consider unexpected, such as the Southeast and Rust Belt states. Conduit opportunities are also available across the country where power generating equipment can be added to tunnels, canals, and pipes. However, projects are not being deployed due to the uncertain, duplicative, and lengthy overall regulatory process. NHA member company Missouri River Energy Services reports that their new project at a Corps of Engineers dam in Iowa will come online in 2018, having started the development process in 2005, 13 years ago. I cannot overstate how crucial it is to enact process reforms immediately. The nation can access huge amounts of reliable, low-cost power without sacrificing other values. Existing project owners are also expressing concerns. With well over 400 projects up for relicensing by 2030, NHA is already hearing from owners, particularly in the Northeast, that the time and cost for licensing may render projects uneconomic and result in license surrenders. Congress must address the challenges both asset owners and developers face. Over the last 5 years, this subcommittee has developed an extensive record on the problems experienced by industry. The message has been clear and consistent. Licensing takes years to complete, requires substantial upfront costs, and contains too much uncertainty and risk, all of which for a developer creates a significant barrier to securing financing or capital, and for a utility makes it difficult to justify project economics. Turning to the bills before the subcommittee today, NHA strongly supports policies to address inefficiencies and improve coordination in the project approval process, which we believe will promote the hydropower resource while also protecting environmental values. I have included specific comments on all of the bills in my written statement and asked permission to include for the record additional letters of support that are submitted following this hearing. Focusing on the Hydropower Regulatory Modernization Act, it incorporates bipartisan proposals that NHA supports and which were included in legislation in last Congress. It is a crucial first step to address the barriers to developing hydropower's untapped potential and the problems experienced in relicensing. Empowering FERC as a lead agency to coordinate the schedule, requiring FERC and agencies to coordinate, facilitating concurrent decision-making, early identification of issues, and elevating disputes to leadership are improvements that should increase transparency and accountability and eliminate delays. However, NHA also believes improvements to the bill are needed as the language appears to rescind important provisions under current law. This includes the requirement for agencies to give equal consideration to developmental and non-developmental values when crafting mandatory conditions, and the opportunity for discovery and cross-examination as part of the trial-type hearings process. These received bipartisan support when adopted and were backed by industry and stakeholders alike. Finally, NHA believes continued work through last year on some of these provisions resulted in new language that provides further clarity and direction and should be adopted. And we believe this hearing creates an opportunity for further dialogue on issues documented in the record but for which solutions were not advanced. And with that, I will conclude my testimony and I look forward to answering your questions.
Thank you, Mr. Leahy. The chair now calls upon Mr. Irvin for a 5-minute opening statement.
Vice Chairman Olson, Ranking Member Rush, members of the subcommittee, thank you for the opportunity to testify today on the hydropower bills being considered by this committee. My name is William Robert Irvin. I am President and CEO of American Rivers, a national conservation organization that works to protect wild rivers, restore damaged rivers, and conserve clean water for people and nature. I also served as a member of the senior peer review group for the Department of Energy's HydroVision report, which was issued last year. Let me begin by stating very clearly that while we are pro-rivers, American Rivers is not anti-hydropower. Hydropower is and will remain a key part of our nation's energy portfolio. Our staff has participated in hundreds of FERC proceedings, resulting in the generation of thousands of megawatts of electricity and improved environmental performance at those generating facilities. In addition, we have supported legislation to incentivize sustainable hydropower projects. American Rivers also recognizes that when sited and operated responsibly, hydropower can be beneficial as a low-carbon, renewable energy source. It is certainly better for the climate than burning fossil fuels, but it is not carbon-free due to the methane emissions from reservoirs. Nevertheless, when sited and operated irresponsibly, hydropower can do great harm to rivers and the wildlife and communities that depend on them. By changing the flow of rivers, hydropower dams have harmed fish, mussels, and other aquatic species and pushed some to the brink of extinction. Hydropower can have toxic effects on water quality. Hydropower dams can dewater stretches of river and have in the past been built with callous disregard of Native American sacred sites and ancestral lands. To prevent these harmful impacts, we have laws in place to protect endangered species and clean water, and to give states, tribes, and federal resource agencies a meaningful seat at the hydropower licensing table. Accordingly, in evaluating any proposed changes to the hydropower licensing process, American Rivers, and indeed the larger environmental community, will vigorously oppose any effort to limit the application of the Endangered Species Act or the Clean Water Act to hydropower dams, to infringe upon state water law and state authority to manage water rights, to limit the protections afforded to Native Americans and Native American tribes in hydropower licensing, to limit the ability of the United States to protect federally managed fisheries and taxpayer-owned public lands, or to limit the authority of state agencies to protect fish, wildlife, and other natural resources within their state. Regrettably, as I have described in my written testimony, the draft bills before the subcommittee fail these tests. At the heart of each of these bills is the flawed principle that FERC should be elevated above other federal, state, and tribal agencies in the licensing process and be able to limit federal, state, and tribal authorities over rivers. Giving FERC the power to decide questions of fisheries biology makes as much sense as giving the National Marine Fisheries Service the authority to decide interstate electricity tariff cases. Giving FERC the authority to decide questions of Native American treaty rights makes as much sense as giving the Bureau of Indian Affairs the final say over reliability standards for interstate high-voltage transmission. And giving FERC the final say over matters of state water law upends the prior appropriation doctrine in the West and challenges riparian water law that goes back to colonial times in the East. The draft bills before you will not improve licensing or promote environmental protection. Instead, these bills will lead to legal gridlock and environmental degradation. I hope that rather than rushing these bills forward, the committee will instead work with stakeholders, including American Rivers, to develop legislation to facilitate responsible hydropower development while protecting healthy rivers, wildlife, and communities. In my written testimony, I've provided some common sense approaches to improving the licensing process without harming the environment. If the committee chooses to convene a stakeholder process to develop licensing reform that maintains protection of rivers, I can assure you that American Rivers will roll up our sleeves and get to work with all the interested parties. Thank you for the opportunity to testify today, and I look forward to answering any questions you may have.
Thank you, Mr. Irvin. And the chair now recognizes for 5 minutes Ms. Dennis for an opening statement.
I want to thank the committee for the opportunity to testify. My name is Jennifer Dennis, and I'm a senior staff attorney with the Eastern Environmental Law Center, representing New Jersey Conservation Foundation and Stony Brook Millstone Watershed Association. The proposed changes contained in the Interagency Coordination Act are unnecessary and would upset the careful balance of cooperative federalism that exists under the Clean Water Act, the Clean Air Act, and the Coastal Zone Management Act. The changes would inappropriately expand FERC's natural gas authority, attempt to undermine states' rights, and undermine the important role that other federal and state agencies play in protecting natural resources for the public. As we have already heard this morning, the proposed changes are a solution in search of a problem because FERC approves over 90% of projects within 1 year. FERC administers applications for both Section 3 and Section 7 approvals on a case-by-case basis, subject to the statutory standards of the Natural Gas Act, operating under no larger federal energy program. These approvals are major federal actions under NEPA, and as such, FERC is required to consider their environmental impacts. Yet FERC uses an extraordinarily narrow approach of its regulatory role under NEPA. For example, FERC has expressed its view that it is not FERC's duty to assess project purpose and need beyond accepting applicants' stated project goal. This approach limits FERC's NEPA review, excluding real analysis of alternatives. FERC will only consider alternatives to natural gas transmission pipelines that are other natural gas transmission pipelines. Similarly, FERC takes an extremely narrow approach to environmental impact assessments. FERC's assessment of environmental impacts routinely finds that a project's environmental impacts will not be significant so long as other federal agencies or state agencies acting pursuant to federal law separately assess the project's environmental harm under substantive statutes such as the Clean Water Act, the Clean Air Act, and the Coastal Zone Management Act. FERC considers authorizations on a case-by-case basis, not subject to any federal energy program or regional planning. As such, FERC's ad hoc authorizations demand robust ancillary federal authorizations by agencies operating subject to comprehensive plans to protect our water and air for future generations. For FERC projects, the comprehensive environmental impacts analyses required by NEPA are consistently performed by those other federal and state agencies in their independent review under substantive environmental laws. Although the proposed bill is entitled Promoting Agency Coordination for Review of Natural Gas Pipelines, the essence of the proposed changes would generate, not resolve, conflict between and among federal and state agencies currently responsible for evaluating the actual impacts of Section 3 and Section 7 projects. In fact, the proposed amendments threaten to abrogate state and federal powers and duties under those laws. Congress carefully allocated cooperative and specific roles for the states and for the relevant federal agencies when enacting those substantive laws. They all explicitly recognize the critical role that the states play in protecting water and air quality. In fact, a key legislative purpose of the Clean Water Act was to uphold the primary responsibility for controlling water pollution that rests with the states. From its inception, the 401 certification requirement was a mechanism to explicitly protect states' ability to regulate water quality standards and pollution control, ensuring their ability to enforce more stringent standards than federal ones. Under the Clean Air Act, Coastal Zone Management Act, the state may also designate standards more protective but not less than federal ones. These NGA amendments would create overt clashes with existing federal statutes designed to protect water and air and to preserve the state's role in that process. For example, the proposed amendments attempting to allow FERC to define the scope of environmental review for the states or agencies acting pursuant to Clean Water Act authority would clearly run afoul of the Clean Water Act's goals. The Clean Water Act is a model of cooperative federalism. There's no need for Congress to disturb this careful balance. Of the hundreds of energy infrastructure projects authorized by FERC, there have been only 3, a tiny percentage, that states have determined cannot be constructed in accordance with controlling water quality standards. Industry cries of abusing reserved and primary powers by the states to protect water quality must stem from a mistaken belief that any certification denials constitute an abuse of authority. I see my time is coming to a close. I'm happy to answer any questions. Thank you for the opportunity to testify.
Thank you, Ms. Dennis. The chair now calls upon Mr. Santa for 5 minutes to give an opening statement.
Good afternoon, Vice Chairman Olson, Ranking Member Rush, and the members of the subcommittee. My name is Donald Santa, and I'm the President and CEO of the Interstate Natural Gas Association of America, or INGA. Our members transport the vast majority of the natural gas consumed in the United States through a network of approximately 200,000 miles of interstate transmission pipelines. These transmission pipelines are analogous to the interstate highway system. In other words, they are large-capacity transportation systems spanning multiple states or regions. Thank you for the opportunity to share INGA's perspective on the discussion draft of legislation to improve agency coordination during the review of federally regulated natural gas pipeline projects. While the Federal Energy Regulatory Commission has exclusive authority to grant the certificate required to construct an interstate natural gas pipeline, various federal and state agencies are responsible for granting other environmental and land use permits and approvals that must be obtained before a pipeline company may commence construction. This is not the first time that INGA has testified before this subcommittee on the need to improve the natural gas pipeline permitting process. The need for action is even greater today because the pipeline review and permitting process has only become more protracted and more challenging. Federal permitting agencies are taking longer and in some cases are electing not to initiate reviews until FERC has completed its review of a proposed pipeline project. These disjointed, sequential reviews cause delay and in some cases create the need for supplemental environmental analysis. This is unnecessary and avoidable. The regulations implementing the National Environmental Policy Act provide for designating a lead agency to coordinate the review of a proposed major federal action. The lead agency in turn identifies and works with cooperating agencies to develop a single environmental document for the project. Congress, as part of the Energy Policy Act of 2005, designated FERC as the lead agency for natural gas pipeline projects subject to the Commission's jurisdiction. EPAC 2005 also provided a framework for FERC to coordinate the various permitting reviews connected with a natural gas pipeline project and to set a deadline for other agencies to complete their work. Notwithstanding the congressional intent expressed in EPAC 2005, it has been a challenge to get federal and state agencies to work cooperatively and constructively within this framework. The recent experience of an INGA member company illustrates the point. The company has proposed a pipeline that would intersect the Blue Ridge Parkway and the Appalachian National Scenic Trail in Virginia. The company proposed a nearly 1-mile horizontal drill under a mountain so that the pipeline would cause no surface disturbances, no tree clearing, and no interference with public access to the parkway or trail. The Park Service responded with indifference to the pipeline operator's efforts to minimize the impact of its project. The Park Service took 14 months to review a 22-page application to survey the area. Once permission was granted, the survey work was completed in a single afternoon. The survey, however, is only an initial step. The Park Service has yet to complete its extensive review of the pipeline operator's application for a permit to drill beneath the parkway and trail. We clearly need better agency engagement and decision-making than that demonstrated by the Park Service in this example. These kinds of permitting delays are becoming much more frequent and are not confined to the Park Service. Because there is no direct accountability for this lack of engagement, agencies with limited resources are free to either ignore or to delay their response to requests to participate in the review of a proposed pipeline project. Let me be clear that INGA is not seeking diminution of the substantive requirements connected with permits that must be obtained to construct the interstate natural gas pipeline. INGA simply seeks greater certainty regarding the schedule for reviewing and acting upon applications for such permits and better coordination among the agencies responsible for issuing permits. We appreciate the committee's leadership in drafting legislation to address this need. INGA encourages the committee to provide even greater structure and detailed guidance so that there is no misunderstanding about congressional intent for the pipeline permitting process. Legislation to achieve this result is not unprecedented or outside the mainstream. The process created by Congress in highway authorization legislation offers a model. INGA encourages you to be bold. INGA's written testimony includes specific recommendations for strengthening and refining the language of the draft bill to achieve its stated goals. We want to work with you in strengthening this bill and make it more effective in coordinating the necessary permitting reviews. Thank you for the opportunity to testify today.
Thank you, Mr. Santa. The chair now calls upon Mr. Black for a 5-minute opening statement.
Thank you, Mr. Chairman. If you'll permit, I'd like to thank Mr. Barton for his nice comments on the sudden passing of my dad, Bill Black, in Houston last week. Dad admired what he did on committee and the floor. Dad would laugh and have me thank the Congress for entertainment over the years, and then he'd tell me to get back to work, so I will. I'm Andy Black with the Association of Oil Pipelines. AOPL represents owners and operators of liquid pipelines transporting crude oil, refined products like gasoline and diesel, and natural gas liquids such as propane and ethane to American workers and consumers. The presidential permit process for cross-border energy pipelines needs reform. The poster child for presidential permit cross-border abuse is well known. The Keystone XL delay from 2008 to 2015 under the previous administration was inexcusable. No permit review process of any kind should take that long. While delay of the Keystone XL pipeline project garnered widespread public attention, there were many other applications stuck at the State Department also facing multi-year delays. Many of those projects were simple changes of ownership filings with no impact on the pipeline's operations or border crossing status. Ironically, the Keystone XL NEPA environmental impact statement conducted by the previous administration found that building the pipeline would do more to protect the environment and avoid greenhouse gas emissions than any alternative, including rejecting the pipeline. According to U.S. government statistics, more than 99.999% of petroleum products shipped by pipeline reach their destination safely. The State Department review found the alternatives to not building KXL and forcing that crude oil onto other modes of transportation would result in 2.6 times more crude oil released and 832 times more releases per year. The State Department study also found the project would provide tens of thousands of U.S. jobs in construction, manufacturing, trade, finance, insurance, professional services, health services, food, accommodations, and more, with more than $2 billion in worker payroll. Good-paying jobs are the benefit of every pipeline project. Whenever a major project is proposed across our international borders or just within the U.S., thousands of jobs with millions of dollars in worker payroll can follow and increase tax revenues to governments. And consumers across the country also benefit from the downward pressure on gasoline and diesel prices that new crude oil supplies bring. As pipeline operators, we know the ultimate reasons for delay and rejection of the Keystone XL pipeline had little to do with the superior safety, minimal environmental impact, new jobs, or consumer benefits of pipelines. Larger forces were at work hijacking this project for their own political gain. Unfortunately, Keystone XL wasn't the only victim of a dysfunctional process. Under the last administration, we saw a review of the simplest pipeline permits with the least amount of environmental impact grind to a halt. A prime example are the several pipelines that run from Canada to Michigan delivering liquid petroleum gases such as propane and butane for industrial uses in manufacturing, chemicals, plastics, and similar products, supporting good-paying jobs in Michigan and beyond. For years, a liquid pipeline operator had presidential permit applications pending for pipelines crossing that border. Under current State Department guidelines, even a change in ownership of the pipeline triggered the need to apply for a new permit. For more than 5 years, the State Department considered whether to issue a permit for something almost as simple as a name change. There were no operational changes of the pipeline, and no change in materials or any physical or environmental impacts, just many years of review, document requests, and delays. We believe the career staff at the State Department faithfully executed their duties under executive authority. However, the current system, with no statutory standards or limits, still left the process vulnerable to manipulation by senior political officials. With no obligations under federal law to reach a timely decision, limit the scope of review to the border crossing, or avoid wasteful reviews of projects with little or no environmental impact, the current process is ripe for abuse. The current administration has returned to the original intent of the presidential permit process, but without reform, a future administration could return to the abuses of the past. Liquid pipeline operators support reforming the cross-border approval process and look forward to working with the committee. Keys to meaningful reforms are the discussion draft's provisions to, number one, provide a statutory time limit for permit reviews after any applicable environmental reviews are complete. Number two, presume approval unless the pipeline is found not in the public interest, reflecting the benefit of reducing dependence on overseas energy suppliers. Three, limit the border crossing permit scope of review to border crossing issues and impacts. And number four, exempt modifications to existing cross-border facilities because they have no impact on the environment at the border crossing. A reformed border crossing approval process will ensure that American workers and consumers wanting access to lower costing energy supplies are not penalized by political manipulation. Thank you.
Thank you, Mr. Black, and thank you to all of you for your testimony. We'll begin to the question and answer portion of this hearing. And I'll begin my question with the 5-minute rounds of questions. First question is for you, Mr. Black, and also before questions, I want to echo the concerns and prayers from Vice Chairman Barton about losing your father, Bill, this past week. As a voice of over 850,000 fellow Texans, your family has our thoughts and prayers in their hearts. Mr. Black, those 850,000 Texans I work for, my bosses called constituents, get why oil pipelines are important. But if I'm the average American, why should I care about whether cross-border pipelines are approved in a timely way? What would you say to those people?
Most Americans want lower energy prices and available supplies of gasoline, diesel, fuel, propane. We've got great supplies in Canada to take advantage of, and Keystone XL and all of the state approvals along the process, they just needed Washington to approve that small border crossing. If that border crossing had been approved on a timely basis, today Americans in your district and elsewhere would be reaping those benefits, but they're not.
That was 850,000 barrels, correct, per day, somewhere in that ballpark being refined there in South Texas, Port of Houston, Port of Beaumont, Port Arthur, is that correct?
Absolutely, supporting thousands of refinery worker jobs.
Thank you. Next questions are for you, Mr. South and Mr. Santa. First of all, Mr. South, Crosby, Texas is not my district, but as a Texan, I say welcome, howdy. But as you know, pipelines are delayed. Companies large and small face uncertainty. Not just the pipeline owners, but the suppliers too. There are the shippers trying to move their products as well. These delays hurt those in the construction industry by looking for some predictable work. Can you talk about how red tape and uncertainty hurts your members and the ripple effect beyond the pipe?
Yeah, as Mr. Black mentioned, those are jobs related to Keystone XL that just simply did not occur. Operating engineers probably have the most labor intensity of any union on a pipeline job. And my written testimony mentioned those other unions engaged in the process with us, the Laborers International Union of North America, the Plumbers and Pipe Fitters Union, as well as the Teamsters. And those are good jobs that just won't occur. On Keystone XL, the remaining segment of it on both sides of the border, close to 3,000 operating engineer jobs alone associated with that. And again, those are great jobs for us in right-to-work communities like South Dakota that have comparatively low wages, where our members would earn over $35 an hour on the check. That's before the extensive investments in pensions, health care for workers' families, as well as training investments that are made there. That's the way we finance the Pipeline Training Fund in association with the Pipeline Contractors Association. That's 75 cents an hour out of every hour worked on a pipeline job that an operating engineer would contribute into that fund for the future of the workforce and to ensure that workers have the skills necessary to make that industry and that specific pipeline as safe as can be.
Thank you, Mr. Santa. How's red tape and uncertainty hurt your members?
Mr. Olson, it leads to capital investment being parked on the sidelines. For example, we took a look at the projects that are being held up by the lack of a quorum at the FERC. And our back-of-the-envelope calculation was that there were about $14 billion worth of pipeline projects that had been sidelined because of that. The delays also have a multiplier effect because, for example, in some cases, certain activities can occur only in certain months of the year due to environmental considerations, like tree clearing. So if one misses that window for tree clearing, maybe the certificate comes 2 months late, but tree clearing can't occur for another 6 months. It also affects, as Mr. Soth said, all of those pipeline contractors and workers who are on the sideline. And then finally, there's an effect on consumers in terms of more gas pipeline projects bring competitively priced gas that brings down home heating bills, electricity bills because gas is being used so much for electric generation, and also all of the inputs natural gas is used with in manufacturing processes that provide jobs and make the United States competitive.
One quick question of curiosity. You mentioned a pipeline in Virginia that's going to be put 1,000 feet under the ground. Is that correct, or a mile underground?
The horizontal length of the drilling that will go beneath the mountain is going to be approximately 1 mile.
1 mile. Keystone's 50 feet, correct? How much does that cost going down 1 mile as opposed to going 50 feet down, which is very safe?
I do not have that figure, but I do know that it adds considerably to the cost of the project, but the intent there was to minimize the environmental impact of it and create a path that would enable the project to get built.
In Texas, we say it's a whole lot of money. And my time's expired. I yield to the ranking member, Mr. Rush, for 5 minutes.
I want to thank you, Mr. Chairman. Mr. Black, I want to also join and extend my condolences to you and your family. On behalf of your father, I know that I admire your courage to come here in the midst of your mourning and your grieving to appear before this committee. I have recently departed wife, so I know what it means and I know how you feel. So thank you. I have a question, Mr. Chairman, for both Ms. Dennis and Mr. Irving. In your professional opinion, do you believe that requiring other agencies to defer to FERC on the scope of environmental review would help expedite the natural gas permitting and hydropower licensing process and lead to fewer or more lawsuits? And the second part of the question is, are FERC staff equipped to determine the scope of environmental review over and above the experts and other agencies with jurisdiction over these same issues?
We heard testimony earlier this morning from FERC itself that FERC is not versed in other agencies' review obligations under their substantive environmental statutes. So allowing a non-environmental agency or requiring a non-environmental agency to define the scope of review for other sister federal agencies or state agencies acting under delegated federal authority would inevitably generate more conflict, more litigation, and end up in really a morass of permitting difficulties as the agencies responsible for implementing comprehensive environmental review programs, such as the Clean Water Act or the Clean Air Act, are required to report to FERC or to explain to FERC why they must require in-depth inquiries of their own that exceed those that FERC would require or look at under the Natural Gas Act.
As I said in my statement, Mr. Rush, giving FERC primacy over other federal resource agencies, over state agencies, and over tribes in these issues would only lead to additional litigation and environmental degradation. The federal resource agencies have the expertise on things like the Endangered Species Act. Tribes certainly have very important concerns that they want to uphold, whether it be with regard to fish and wildlife resources or things like sacred and ancestral sites. And the states have great expertise and authority in evaluating water quality certification under the Clean Water Act. There's also a well-established body of law under the Federal Power Act that deals with this interaction among the various agencies. And the courts have been very clear that the resource agencies, the federal resource agencies, and the states have the authority to enforce the Clean Water Act and the Endangered Species Act, and that FERC needs to defer to those agencies in doing that. If as these bills would do, you upset that well-established body of law, you got to figure out how's it going to work going forward, which invariably will lead to additional litigation.
One thing I want to ask Mr. South. I come from a district where there's very, very high unemployment. And notwithstanding these matters that we're discussing now in terms of the pipeline. How do you foresee in your training programs, how do you deal with the question of diversity in your training programs? Because my experience as a member of the city council in Chicago is that we've always had problems diversifying some of the unions, trade unions in Chicago. So how do you see this going forward, the issue of diversity in your training and your employees?
Apprenticeship, Congressman, is really one of the key methods by which we bring new entrants into the industry, and it's a key method to increase the diversity of the union. Within our apprenticeship programs at the IUOE, 23% of apprentices are people of color. We've got 8% of women in our construction, 8% of apprentices are women in our construction programs, and that's an objective for our leadership to pursue diversity, and really apprenticeship is that primary method and tool by which we increase our numbers of people of color and women in the trade.
Gentlemen's time has expired. The chair calls upon the gentleman from Virginia, Mr. Griffith, for 5 minutes.
Thank you very much, Mr. Chairman. I do appreciate it. Mr. Santa, you may be aware of this, but I'm going to use you for a minute as an example. I'm always talking about my district, which is the 9th Congressional District of Virginia, and that sometimes the policies of the previous administration related to coal didn't take into account that every mountain is different. In relationship to the pipeline that you're referencing, it's a perfect example of why you have to look at every mountain a little bit differently, because not only does it affect the Appalachian Trail and the Blue Ridge Parkway, as you mentioned, and you mentioned it reduced the environmental risk. For those who don't know, and I'm sure you do know, but that was all about a salamander that lives on one mountain in Virginia. And the mountains of Virginia, the Appalachians in Virginia, have lots of those kinds of things that happen. A salamander that might only live in 1 or 2 mountain areas. The same is true for our mineral deposits. And sometimes one mountain will have lots of gas in the coal mine, and the next mountain won't have any gas at all. And they can be very close together. So you gave me a perfect example to explain to folks what I've been talking about for years. You got to look at every mountain a little bit differently, which is why we ought to leave the Clean Water Act and allow the states to make a lot of these determinations, because every mountain is different, every river is different, and that brings me to rivers, Mr. Irvin. You indicated, and I'm not going to ask you to give me a dissertation today, but if you could send me the information on how you think that the bill, or one of the bills that we're talking about today, impacts riparian rights in the East, I would greatly appreciate it, because it's of interest to me. Because we were talking earlier today, and a couple of us got together down here, and they were talking about how the rivers belong to everybody, except there are exceptions. Because in my district, there's a part of the river that the king gave the entire river, not just a piece of it, not just the water, the whole river. And as a result of that, there are people who can actually keep other folks from floating down the river because they own that surface right there. So it's very interesting. But if you could forward that to me, I'd greatly appreciate it.
We'll be happy to do that, Congressman. And each state has the responsibility for water rights and water law in their states, and it varies from state to state with a big difference between the West and the East.
Yes, sir.
That's why changing the law to give FERC authority or primacy over states when they're seeking to protect their rivers and waters is so problematic.
And not only do we have King's grants in Virginia, but obviously the Eastern law is based on the English common law, and the Western law is based on the European continental methods or models. Mr. Leahy, now to the subject I was really supposed to talk about in my questions, but I do find your testimony, and sometimes when you get late in the hearing, you think maybe it's not making any difference. We are paying attention. But the closed loop hydropower, my region is very interested in this because we believe it's a way that we can bring life back to some, not obviously you aren't going to have hundreds or thousands, but a couple of abandoned coal mines in our area. So I would ask you to discuss what you believe might be some of the possibilities for using that kind of technology or that kind of a system in our abandoned mines.
Sure, absolutely. And as FERC testified earlier today, they've already approved one project that has a very similar configuration, a different type of mine than a coal mine. We have seen a growing list of proposed projects across the United States for both open loop and closed loop pump storage in the type of arrangement that you're talking about. So we see that there's great potential for these types of projects. One thing that I would like to say with regards to the modernization bill is that we do not read that bill to repeal any of the authorities of the states, the tribes, or the agencies. They still have those responsibilities, and NHA believes those are appropriate responsibilities under those laws. What we believe the bill tries to do is to get FERC in charge of putting together the coordination of the schedule. And as others have talked about on this panel, and as I said in my testimony, when you have projects that are going not just 2 years, 4 years, 6 years, but 8, 10, 12, or 14 years from concept to construction in operation, that's almost a death knell for those projects.
And I appreciate that. And I will take a look at that language very carefully after having reviewed Mr. Irvin's information, because I'm very interested in property rights and the historical rights of the various states. Likewise, on the Shore Act, which you all have not taken a position on, one of the reasons that I really like that act, and it was introduced previously by my colleague Robert Hurt, he decided to retire, and since I'm affected by it too, I picked up the language that has previously been approved by the House. But one of the reasons I'm so interested in it is I did some property right cases on a lake one time, and they don't have all the power that they didn't acquire as much as they thought they acquired when they did the deeds back in the 1950s, and they're, I think, stepping on some property rights. So I'll be looking at that too.
Well, and Congressman, we would be happy to work with you on that bill going forward. Like I said in my testimony, we just want to be sure that the safe operation of the project our members are able to continue to do that.
And I think we can have both interests secured in the end. But I appreciate it very much. And with that, Mr. Chairman, I yield back.
Gentleman yields back. The chair now calls upon the gentleman from California, Mr. Peters, for 5 minutes.
Thank you, Mr. Chairman. First, I want to start by acknowledging my Duke classmate. It's traditional for you to talk about Duke basketball with Mr. Santa. We skipped over that part, but maybe we'll leave it to another time. I had some questions about hydro. I want to ask Mr. Leahy, there's been some concern about whether there's a patchwork of state regulations that talk about whether hydropower counts as renewable. Mm-hmm. The draft legislation that we're considering today attempts to take that on. Are you satisfied that that this draft clarifies that so that all hydro is considered renewable?
I believe there is a sense of Congress in the provision that would say that all hydro is renewable, and then it would go back and amend the EPACT of 2005 definition to include all hydro as renewable. I think that's very important, and to the extent that other statutes and regulations parry off of that definition, then I think that will create, it will do what it is intended to do, which is to make hydro renewable. If there are other statutes or regulations which have their own definitions, then I'm not sure. We may have to do some more.
And you just mentioned that there's, in your written testimony, there's discussion of the avoided greenhouse gas emissions from hydro. Mr. Urban made a comment about methane. Have you tried to quantify exactly how much greenhouse gas we avoid by using hydro?
There is research that is being done by the Department of Energy and internationally. I would note that the International Panel on Climate Change has not regulated in this area or made recommendations in this area because of the fact that the science is not there yet. In addition, there is this issue with regards to the net emissions of reservoirs. There is some of this degassing that happens naturally. Right. And we would also point out that reservoirs are multi-use, yeah. Right? So a project, it's not, any emissions, if there are any, should not be ascribed to the hydro generation when it's also potentially being used for water supply for cities or for irrigation for farms.
Okay, and any research that you had on that, if you could forward to us, would be great. It's my understanding that about 40% of the U.S. Army Corps' hydropower fleet is 50 years old or older, and increasingly that the Army Corps is engaging in public-private partnerships to finance many of its projects. you see that an opportunity for that in the hydropower realm?
It is probably the largest opportunity that near-term opportunity we have of the projects that have been identified by the Department of Energy. 80 of the top 100 projects are on Army Corps of Engineers dams.
Do you see that the law authorizes today those partnerships, public-private partnerships, to finance those improvements?
Most of the financing is, in my understanding, most of the financing that is being done by the private entity, and then coming on to the core facility. There might be some opportunities for additional public-private partnerships with the core directly.
Yeah, I just want to make sure. Is the law authorize this for the hydro facilities? Do you think it does?
I would have to get back to you on that one. I know that there are some differences between what the Corps can do with.
Apparently, there's some concern within the Army Corps that it doesn't. And if you think it needs to be changed, we'd appreciate knowing that.
I think there are some changes that are needed. I just need to get back to you on what those specifics are.
Thank you. And then I'd ask Mr. Irvin. I just think we argue a lot about process, and I don't want to give a misimpression about my interest in hydro. I want resources to be protected. But I see a concern in the amount of time it takes. So with my minute left, do you have ideas about how we could reduce the time it takes to get these permits and these hydro facilities operating and still protect resources? Is there a way we can reduce the amount of time?
Certainly. We've laid out several of these in my written testimony, Mr. Peters. They include things like presumptive inclusion in the FERC study of plans of studies requested by federal, state, and tribal agencies. Do that up front. Promoting memoranda of understanding between FERC, the tribes, and the states to improve the coordination. Again, do that up front. There is a need to increase appropriations to the agencies. I know that isn't always a popular topic, but the fact is that they need more money and staff in order to do a better job. And we also can have improved coordination between FERC and the Army Corps of Engineers on these various projects.
Yeah, and I'll just say, I hope we can have a more conversation about this. A lot of this is not really changing the process. I think it's sort of adding more to the process, and it provides, I think it's still difficult for me to understand in an objective way what improving coordination means and how we force that from this room. So I'll look forward to more conversation about it and hope that we can come up with a way that advances this interest that I have in reducing greenhouse gases, but also protecting rivers, which is what we all want. And Mr. Chairman, thank you for the time.
Gentlemen's time has expired. The chair would like to inform the gentleman and Mr. Santa that my wife is a 1985 Duke graduate. So the NCAA basketball tournament this year was a very dark, dark time in the Olson house. The chair now calls upon the gentleman from Missouri, Mr. Long, for 5 minutes.
Thank you, Mr. Chairman. I'm glad I came to this hearing today because I didn't even know they played basketball at Duke's. Mr. Santa, you mentioned in your testimony that the pipeline review process is disjointed. I didn't know if that was meant as a pun or not, but that being said, could you discuss why the process is disjointed, and do you believe that the discussion draft adequately addresses this issue to encourage a more coordinated review process?
Thank you for the question, Mr. Long. As Vice Chairman Barton observed earlier, I mean, the discussion draft is trying to get at what the Congress and this committee was very influential in. It did in the Energy Policy Act of 2005 in finding a way to affect that congressional intent. I think that the process is somewhat disjointed because, as was noted by Mr. Turpin earlier, there are other federal and state agencies that have got multiple mandates, and for them at times issuing these permits that are essential to construct pipeline infrastructure may not be a high priority. They may not have the resources to do it. And as I noted in my testimony, there are times when there is quite a bit of unreasonable delay that affects the ability to construct these projects on a timely basis. I do think that the discussion draft would improve the process. In our testimony, we offer some examples for ways that it can be strengthened. So we think the committee is headed in the right direction with the discussion draft, and look forward to working with the committee on perfecting it.
And the current regulations provide for establishing deadlines for final permitting determinations. Could you discuss how effective this current process is?
It unfortunately has not been very effective. One of the problems is that notwithstanding that being part of the 2005 law, there really wasn't anything put in there for effective enforcement in it. The only recourse was for the pipeline applicant to take that permitting agency to court. That's awfully difficult because effectively you're suing the agency from whom you're trying to get the permit. And also the standard of review applied by federal courts of appeal tends to be pretty permissive and highly deferential to the agencies. And so in the limited instances where pipelines have chosen to litigate under that provision, it has not been very satisfying.
Do you believe the discussion draft that provides accountability for failure to meet the deadlines?
I believe that it does to the extent that it requires those agencies that have not met the deadlines to report to the Congress. That provides a process for attempting to resolve it within the administration, and also requires them to specify a plan for what they can do to complete their work. It is a challenge because, as has been noted by the witnesses on the committee, those other agencies are acting pursuant to their particular legal mandates. We respect that, but we're just looking for a process that will give us more predictability and more timeliness in terms of obtaining the permits that are needed.
Okay, thank you. And with that, Mr. Chairman, I yield back.
Gentleman is back, and the chair reminds the gentleman the last time Duke played Missouri in the tournament was March 17th of 2001, the East Regional Final, Duke 94, Missouri 81.
I didn't know they played basketball in Missouri.
Seeing there are no further members wishing to ask questions for the second panel. Oh, I'm sorry, Paul. I apologize. The chair now calls upon the gentleman from New York, Mr. Paul Tonko, for as much time as he wants.
Rescued by the buzzer. Thank you, Mr. Chair. Ms. Danis, as you know, the interagency coordination discussion draft would allow remote surveying data to be considered by agencies. Can you explain how aerial data may be insufficient?
Aerial data, as we heard testimony earlier this morning, provides an extremely limited view of what's on the ground. It cannot be accurate with respect to wetlands delineation, cannot be accurate with respect to endangered species, vernal ponds, seeps, vegetation, other things that require detailed on-site surveys. And the provision in the amendments for aerial survey data requiring ancillary federal authorizations to consider those data simply decreases efficiency because it, in essence, asks, for example, states under 401 certification to consider an application based on guesswork a first time, and then to go back and to reconsider that same application once they can make a true determination of what the on-site environmental impacts would be. It's a very inefficient way of approaching it. And one way to increase efficiency and reduce delay in the permitting processes would be to require the applicants to come to the table with completed applications, first when they approach FERC, and to not put FERC in the position of routinely asking for submitting deficiency notices, asking for additional environmental data, but to come to the table from the outset with a well-conceived plan supported by data.
Thank you. And in addition to perhaps not providing the sort of accuracy we need, you also see that requiring agencies would be ultimately caused to spend more time, perhaps, and more resources in reviewing applications because of the concerns you just mentioned?
It would, because each agency under their enabling statutes retains the authority to determine when they have sufficient and verified data to make that assessment. This would inevitably increase those agencies' resource expenditure to consider applications that are substantially incomplete from an environmental ground truthing perspective.
Thank you. And Mr. Irvin, in the licensing study improvement section, I believe it's page 19 of the Hydropower Policy Modernization discussion draft, we would place the onus on agencies rather than applicants to prove that a study is not duplicative. How might that undermine an agency's ability to get the information that agency needs, especially when dealing with a potentially short timetable?
Well, agencies are of course, stretched thin for all of the work that they have to do. And anytime you put the burden of proof on the agency to basically to disprove something, you're adding to that burden. You're making it much more difficult for them to carry out their responsibilities. And what we're talking about here is a licensing process where a private entity wants to do something to make money at it, and it seems fair to require that going through that licensing process, they bear the burden of making the case for why they are entitled to a license.
Would there be any reason that the burden of proof should not fall on the applicant when asked to meet study requests by agencies?
Not that I can think of.
Okay, thank you. And Mr. Urban, again, at least in some cases, delays in hydropower application and evaluation seem to be primarily caused by failure to provide all the information necessary for federal and state agencies to do their jobs. How important is it to get this information and include all interested stakeholders early on in the process?
It's absolutely crucial. If you pick the right site and you get the information lined up, the statistics show that the process through FERC is actually fairly expeditious, a couple of years to get a license. What often happens is that an applicant will choose to go through the traditional licensing process, which takes longer. And also, it sometimes is actually in the interest, particularly in a license renewal situation, for the applicant to have the process take longer, because what happens then is that each year they get a one-year extension of their existing license. They don't have to undertake any of the environmental mitigation that would be required once they get a new license. And so continuing the process for a long time actually may be in the interest of the applicant. That's not, obviously not a preferred outcome. We want to get through these processes. We want to get the new requirements in place. We want the applicant to get their license expeditiously. We can do that through the existing processes. We don't have to weaken existing environmental law in order to achieve that.
Thank you. Mr. Chair, is there an opportunity for one more quick question?
Yes, sir, absolutely.
Thank you. Mr. Irvin and Ms. Danis, though you provided testimony on completely different subjects, your statements were remarkably similar in that they both focused much of their time on the relationship between the legislation before us and the Clean Water Act and how that legislation would undermine it. Specifically, you both focused on how the bills would harm states' rights under Section 401 of the Clean Water Act, as well as water rights generally. So my question to each of you is, it seems to me that these bills are, in large measure, attempts to make significant changes to Section 401 of the Clean Water Act, and to a somewhat lesser degree in Section 7 of the Endangered Species Act. Would you agree with that assessment?
Absolutely. That's one of the primary problems of these bills, is that it undermines both the Endangered Species Act and the Clean Water Act, and in particular for the Clean Water Act, the state authority to decide what qualifies for a water quality certification.
Thank you. And Ms. Danis?
I agree with what Mr. Irvin just said, and additionally, it's really important that those comprehensive and well thought out national policies that are embodied in the Clean Water Act and the Clean Air Act are not scuttled for the purposes of consideration of private applicants' projects on a case-by-case basis, but really affect the Natural Gas Act goals of balancing those interests.
Thank you very much. With that, Mr. Chair, I yield back.
Thank you, Mr. Tonka. We saved the best for last. Now, seeing there are no further members wishing to ask questions for the second panel, I'd like to thank all our witnesses, Mr. South, Mr. Leahy, Mr. Irvin, Ms. Danis, Mr. Santa, Mr. Black, for being here today. As we conclude, I'd like to remind everybody here.
Mr. Chairman.
Yes, sir.
Mr. Chairman, I began this hearing with some very serious concerns about the status of our chairman, Fred Upton. I wanted, have you had any latest? Is he all right?
Chairman Fred Upton is fine. He's doing well. He's been working on the health care bill. God bless Fred Upton. As we conclude, I'd like to remind everybody here that my Houston Rockets are looking to go 2-0 up against the San Antonio Spurs. Tip-off is at 9:30 p.m., so take a nap. I'd also like to ask your consent to submit the following documents for the record: a letter from the Edison Electric Institute, a letter from the Modesto Irrigation and Turlock Irrigation District of California, a letter from the Southern California Public Power Authority, a letter from the Public Utility District number 1 of Chelan County, Washington, I hope they pronounced that right, letter from the Jordan Hydroelectric Limited Partnership, letter from the County of Pulaski, Virginia, letter from the NECA, the National Electrical Council Contractors Association, letter from Public Utility District number 1 of Okanogan County, Washington, letter from the American Public Power Association, letter from the National Electrical Contractors Association, letter from testimony of Kevin Colburn on behalf of the American Whitewater, series of letters collected by the Hydropower Reform Coalition, letter from Western Government Association, letter from Mayor Linda Dahlmeyer of Oroville, California, letter from the Hydropower Reform Coalition, and finally, the Fast 41 Federal Permit Improvement Steering Council fiscal year 2017 annual report to Congress. That's it. That's that be submitted for the record. Without objection, so ordered. All members that they have 10 business days to submit additional questions for the record. Ask witnesses to submit their response in 10 business days of receipt of those questions. Without objection, this committee is adjourned.